Are we set? Ready to go? What you going to be using that for? Various?
A bunch of things. Jury instructions, photos, videos, a lot of things.
Just show them to me if you can, or tell me what you're referring to. I should have it.
They're all the exhibits that were in evidence.
All right. I just wanted to sit back here and not over there. All right. Well, we'll cross that bridge when we get to it. Go ahead and bring them in. I did tell the jury, because hang on one sec.
Let's give them just a few minutes.
Yeah. Because of the long time we're going to go, I told them to tell the jurors that they can have snacks in there.
The judgment may be a little bit less than 3 hours.
Okay. Okay.
2.5.
Okay. I anticipated that, and it is what it is. Yeah, there we go. Okay, ready? Did you?
I think they had asked for
What?
another minute.
Who, the jurors?
Yeah.
Oh, okay. Yeah.
Jury, you're in the courtroom, you're off.
All righty.
Jury may be seated. All jurors are present and accounted for, Your Honor.
Thank you, Deputy. Ladies and gentlemen, were you all able to abide by my instructions during the recess? All right, very good. We'll go ahead and get started. Mr. Escobar?
Thank you, Your Honor. Counsel.
I better reposition. Good, Mr. Escobar.
You don't judge a person until you have walked a mile in their shoes. It's a very wise old saying, and one that actually is embodied in the laws of self-defense, not only in the state of Florida, but in this country. The Constitution of our great country embodies the right and the law of being able to defend yourself. There's a great wisdom in our laws, both nationally and here locally. A great wisdom. That wisdom in the law of self-defense starts with a term called perception. You're going to work with that term throughout your deliberations in this case. Because the law protects that reasonable perception. Reasonable perception. You have to walk in the shoes of someone before you judge them. You've got to walk a mile. The law of self-defense requires us all to judge the reasonableness of that perception, not here in the comfort of a courtroom, in the protection of a courtroom with deputies that are armed to give us that security. The law of self-defense requires each and every one of us to stand in the shoes of Curtis Reeves, a 71-year-old man at the time of this incident, a decorated law enforcement officer who had countless and countless hours of training in the use of force, in the assessment of danger, and the risks that take place when we are faced with a dangerous encounter. Curtis Reeves, at the time of this incident, had more knowledge, more experience, more study in that area than anyone in this courtroom, and certainly anyone that was responsible for investigating his fate. Perception. The prosecution came up here. I think I counted, we're probably at 28 to 30. It doesn't matter. This doesn't matter. This doesn't matter. This doesn't matter. This doesn't matter. And by the way, this doesn't matter either. And this doesn't matter. And by the way, this doesn't matter either. Ladies and gentlemen of the jury, everything matters. Do not discount anything. Do not discount anything that we do and we say and we present, and do not discount anything that the prosecution presents either. Because it matters. We live in the greatest country in the world that considers our system of justice the very best. And the very best because we have to consider the evidence. We have to analyze the evidence and judge that evidence. And this very court, the judge, is going to instruct you on a great deal of rules that you can apply in this case. I'm going to ask you to thoroughly review every one. We're about to start doing that ourselves. I'm going to take you first through those rules, and then I'm going to take you through every piece of evidence that came before you in this case. And it does matter. Matt, it's your instruction. Plea of not guilty. Mm-hmm. The court's going to instruct you on an instruction called plea of not guilty, reasonable doubt, and burden of proof. It is the bedrock. It is the foundation of our system of justice. And one of the reasons that it's one of the first ones is that that's where you start. This is where we start, all of us, in administering justice in this very courtroom. And what does it tell us? What does the wisdom of this law tell us? It tells us that Mr. Reeves has entered a plea of not guilty. And it tells us that this means that you must, not can, you must presume or believe that he is innocent. That's how we start this trial. There's a reason for that. There's a reason for that. Because it's not Mr. Reeves' obligation to prove his innocence. It's the prosecution's obligation to prove not only the crimes alleged, but is to prove beyond and to the exclusion of every reasonable doubt that the defense of self-defense is not present. That's his burden. So we start with that presumption. And where does that presumption go? That presumption stays with the defendant as to each material allegation. At each stage of the trial. Unless it has been overcome by the evidence to the exclusion of and beyond a reasonable doubt. Very powerful instructions for the protection of our liberties. Up a little bit, man. Let me take this off first. Okay. Reasonable doubt. That's a word that, again, you're going to be instructed by Your Honor, that you're going to be considering in this particular case. And so, wherever the words reasonable doubt are used, reasonable doubt is not a mere possible doubt, a speculative doubt, an imaginary doubt, or a forced doubt. Such doubt must not influence you. However, on the other hand, if after carefully considering, comparing, and weighing all of the evidence, all of it, ours and theirs, there is not an abiding conviction of guilt. An abiding conviction of guilt. Or, even if you have that conviction, but it is one which is not stable, but one which wavers and vacillates, then the charge is not proved beyond and to the exclusion of every reasonable doubt. That's your guidance in this case. And one that, no, we cannot say that doesn't matter. That is not our system of justice in America. Where do we look? Where do we look for that reasonable doubt to determine guilt or innocence? Where? It is to the evidence introduced at this trial, and to it alone, that you are to look for that proof. And to it alone that you are to look for that proof. Where can that reasonable doubt arise? From the evidence, conflict in the evidence, or lack of evidence. Now, the prosecution says, look, we had horrible law enforcement officers. It doesn't matter. It doesn't matter. I about fell out of my chair. It always matters in our system of justice. It always matters. If you have a reasonable doubt, you shall, not can, not possible, you shall find the defendant not guilty. Because it's their obligation and it matters. I need to blow it up on that last part. Thank you. If you have no reasonable doubt, then you shall find the defendant guilty. It goes both ways. Next one, Matt. Justifiable use of deadly force. This is an instruction that the court is going to give you, and you are going to be able to work with this instruction for a very important function in your decision. Justifiable use of deadly force. Our Constitution, the laws in Florida, protect us as citizens to be able to defend ourselves in the face of danger. That's why these laws were enacted by the legislature, and that's why we have a Constitution not only of the United States of America, but also a Constitution of the state of Florida. And in looking at this instruction, the use of deadly force is justified if Curtis Reeves reasonably believed that the force was necessary. Remember what I told you from the very beginning? You don't judge a person until you have walked a mile in their shoes. That doesn't say you judge Mr. Reeves by what the prosecutor here has experienced in life. You only judge Mr. Reeves and you step in those shoes as a 71-year-old former decorated law enforcement officer that not once in his entire career fired his weapon in the line of duty, that was asked to start one of the most dangerous squads that you could have in a law enforcement department. An individual that traveled the entire country to learn those cues to prevent that danger from happening. In the law of self-defense, it doesn't tell you, get smacked first, Get punched first, and then you can see what you can do. Because as their witnesses themselves have told you, law enforcement, medical examiner, you name it, one punch can cause great bodily harm, and one punch can cause death. You've got to stand in the shoes before you judge someone. What else was in those shoes? What else were in those shoes? You were in a theater, in a darkened time of that theater. Previews were playing loud. The distance between Mr. Reeves and Mr. Oulson was extremely short. You remember in opening statement, Mr. Lawson said, "Oh, he was in that row way over there." Did they even give you any measurements here? Not a single measurement was given to you by the prosecution. Because they want you to think that that particular distance was a row way over there where this was happening. But that doesn't work, because you've got to stand in the shoes of Mr. Reeves as he was seated there in that seat at very close range to Mr. Oulson. When you're applying this very instruction, because Curtis Reeves reasonably believed that the force was necessary to prevent, circle it, prevent. You don't get a punch first and then you get the justifiable right to defend yourself. That's not how it works. To prevent imminent death or great bodily harm to himself while resisting an attempt to commit the felony offense. We're going to talk about this one. The felony offense of battery on a person 65 years of age or older. Now, the wisdom of the law. 65 years of age. If I go over to Miss Flores, and I go to Miss Flores, and she doesn't want me to touch her, but I do this. It's called a misdemeanor battery. Miss Flores is, I won't tell you her age because she's young. But the law has recognized that the aged in our community are vulnerable. And they have sought that wisdom to say, if the aged are vulnerable, we've got to protect them. Because one battery, one misdemeanor punch could cost them their lives. That's not Rick Escobar saying that. And that's not this prosecutor saying that. That is our legislature that have, through countless studies, have determined that we've got to protect those that are most vulnerable. And so they've elevated, think about that, they elevated a misdemeanor crime to a crime of a felony that you can spend 5 years in the Florida State Prison.
Objection, improper argument.
It's a felony of the 3rd degree. That you can spend 5 years in prison if you batter the aged. Now, let's continue. A person is justified in the use of deadly force, again, if he or she reasonably believes that such force is necessary to prevent imminent, hasn't happened yet, imminent death or great bodily harm to himself or to another. Or to another. Who did we have in this theater seating in rows 9 and 8? Curtis Reeves, Vivian Reeves, both up way beyond 65 years of age. The imminent commission of an aggravated battery. That's another way. Not just someone 65, you can do it this way. Totally justified. There's another way. If in fact someone's committing an aggravated battery, the throwing of a phone. Their witnesses, not even mine. I brought officer after officer. Officer, tell me, what can cause great bodily harm, which is an aggravated battery? Oh yeah, fist cannon, phone if it's being used as a weapon. Just about, I believe one officer said, just about anything can be used as a deadly weapon. Up a little, man. So those two sections give you, this is what can justify the use of deadly force. But now, how are we going to make that determination? Because in deciding, that next paragraph is in deciding whether Curtis Reeves was justified. So, in deciding whether Curtis Reeves was justified in the use of deadly force, you must, not can, not maybe, you must judge him by the circumstances by which he was surrounded at the time the force was used. All of the circumstances, his knowledge, his close proximity to the individual, the low lighting conditions, the noise level, the problems that he was having physically. I think that when you all, and we're going to talk about Foley a bit later, not only did you hear from Dr. Foley, again, one of the preeminent radiologists in the country, not only did you hear from Dr. Foley, but he showed you on the x-rays and the MRIs some of the most trusted procedures that all of us in our lifetime at some point in time will have. And he showed you area by area by area of Curtis Reeves' problems. Disc herniations, impingements on the cord, his actual skeletal system from the very back. I'm not going to bring out the skeleton, but all the way down the back, he had black discs, all the way back, bone on bone. Bone on bone in his hands, bone on bone in his back, bone on bone in his cervix. You've got to stand in those shoes, because that's what the law requires. All of the circumstances, every single one of them. It's not what Rick Escobar would do. It's not what the prosecution would do. It's what someone in Mr. Reeves' shoes would reasonably do. That's the beauty of the law. It does not punish individuals that reasonably perceive that danger. That's the beauty of our Constitution. That's the beauty of the law of self-defense, that it does not punish the reasonable perception of an individual that is facing danger. And let's even talk about the danger, because it goes one step further. It tells you the danger facing Curtis Reeves need not have been actual. Need not have been actual. That danger didn't have to be actual. But as long as he reasonably perceived that it was a dangerous situation, the law protects us. There may be other courts in the civil arena that someone can pursue, but in the criminal arena, the law does not punish those that reasonably perceive that they're in imminent danger of great bodily harm or death, even if that danger is not actual. The appearance of danger must have been, however, real, and that a reasonably cautious and prudent person under the same circumstances, again, would have felt that that danger was so real. It does matter. Everything matters. Based upon the appearances, Curtis Reeves must have actually believed that the danger was real. It's another very important paragraph right below it. And again, it's protected by the U.S. Constitution, the Florida Constitution, and our Florida laws. And as we walk in society, and as we interact with people in the great state of Florida, we're protected by these laws. And what does it say? That as long as Curtis Reeves is not engaged in unlawful activity, which there's no question he was not, was at a movie theater, getting ready to watch Lone Survivor, watching the previews. So there's no question that there was no unlawful activity. And was attacked in any place where he had the right to be. Certainly he had the right to be at the Cobb Theater to watch The Lone Survivor. He had no duty to retreat and had the absolute right to stand his ground and meet force with force. Including deadly force. Those are the protections that all of us as citizens of this great state enjoy. It's a dangerous world we live in. Things happen in split seconds. It's very difficult to judge what comes next. It's very difficult to understand the makeup of that person that's about to attack you. But there are cues that officers, former officers, retired officers like Mr. Reeves have been taught that hopefully protects them and allows them to prevent that fatal blow to strike. Those cues. It wasn't only Dr. Bedard. Again, you know, they complained that our experts were expensive. Our system of justice wants that. They want to get it right. Our system of justice does not want to get this wrong. They complain that our experts charged an hourly fee. to help in the investigation of this case. Roy Bedard, one of the nationally recognized experts in use of force. He wasn't my expert only, right? Remember what he told you on the stand? Roy Bedard testified for this very prosecutor months before. This very prosecutor. He wasn't about to testify on this one for him.
Objection, improper argument.
Sustained.
Did they touch him with a 10-foot pole? Did they even come up and chat with him about his opinion? His opinion, which was the most important opinion, that Curtis Reeves did not fire that weapon in response to popcorn being thrown. His theme, his primary theme that he came up here, he said, ladies and gentlemen of the jury, this is about a man that shot another man over popcorn. Their expert witness, Roy Bedard, got up here and under oath said, absolutely not. 0.72 seconds between that period of those hands coming to grab that popcorn and the firing of the shot. Remember, Roy Bedard said there's an action and a reaction. The human body takes time to perceive what you're seeing, to decide what you're going to do from that act, and then to carry out the act. 0.72 seconds. Impossible. They didn't touch that with a 10-foot pole. They could have brought Roy Bedard for the government. Let's not even go to Roy Bedard. Let's go to Detective Aaron Smith. Remember all the questions I asked him about his training? Hey, we have training on use of force. Yeah, we have these training exercises, and we look at all these cues, and yeah, it's really scary, Rick, when we fail. Really scary, Rick, when we fail. Did you hear Aaron Smith get up here and say that the shooting of Mr. Reeves was about someone throwing popcorn on him? They had Mr. Smith right in their little palm right here to just ask him one, maybe two, maybe three questions on that issue. Not a peep. They stayed away from that 10-foot pole. I'm not going there. Again, it's constant. If he reasonably believed that it was necessary to do so to prevent death or great bodily harm. But here doesn't say that Mr. Reeves had to try to go and run out of the theater before he used deadly force. Perceives the danger. That danger is reasonable in his shoes. He can defend himself under the Constitution of the United States of America. He can defend himself under the Constitution of Florida. And he can defend himself under the laws of self-defense in the state of Florida. And if he doesn't, it could cost him his life. Another very interesting portion of the wisdom of the law. And our laws are very intelligent. Look what this section says here. In considering the issue of self-defense, the members of the jury, you may take into account the relative physical capabilities and capacities of Curtis Reeves and Chad Oulson. Why does the law do that? Does the law do that because they recognize that a 40-plus-year-old man, 43, 40-year-old man, 6'4", 200-pound man, is much more dangerous when he is attacking a 71-year-old man with the physical problems that he had on January the 13th of 2014. Of course, that's what they're telling you. You've got an individual that has much more capabilities at 40, 43 than an old man at 71, even if you don't consider his physical issues. You judge an individual after you've walked a mile in their shoes. It's a very wise old saying that has great practicality in the application of the law. If in your consideration there's an issue of self-defense and you have a reasonable doubt on the question of whether Curtis Reeves was justified, you shall. It would be a miscarriage of justice if we don't. You shall find Curtis Reeves not guilty. That's not me. The court is going to give you that instruction. The court is going to tell you the importance, ladies and gentlemen of the jury, of applying this law and applying these rules to the evidence that you've heard. There is absolutely no reason not to apply these laws. They're laws that we all follow as citizens, again, of this great country, to make sure that in each and every case, justice is carried out. A miscarriage of justice is the absolute worst thing that could ever happen in our system of justice. Matt, can we go to the next one? Transferred intent. I want to talk a little bit about transferred intent if we can, because it's a concept that sometimes you may need some explanation. But it's a short one, not a long one. And I think the prosecution gave you a little bit of insight that the intent transfers. The intent to do harm against one person, but you end up doing harm to another person, that intent transfers. But just as important is that if, in fact, if the death of Chad Oulson resulted from the justifiable use of deadly force, if you find that the death of Chad Oulson resulted from the justifiable use of deadly force, you must, not can, not maybe, you must find the aggravated battery or the felony battery or the battery of Nicole Oulson was justified. Meaning the battery on her, the aggravated battery, the felony battery on her. You must find that it was justifiable. And why? Because the initial act by Curtis Reeves in defending himself against Chad Oulson was reasonable in his shoes. For a second, we're not going to use the board. Want me to turn it off?
Yeah.
Ladies and gentlemen of the jury, who is Curtis Reeves? Who is Curtis Reeves? One of the most decorated, accomplished, police officers in the history of the Tampa Police Department, you're going to have an opportunity to see, not all of them, because unfortunately back in those days, in the 60s, they didn't keep all of the training manuals and all the training documents. But you're going to see a stack of training that this individual attended and was certified all over the country. If you remember, he initially went into the Navy, and from the Navy he went to go work for GTE for a couple of years, and then he applied to become a police officer. An individual to serve our community. An individual that walked out of his home every day not knowing whether he would return. Not knowing whether he would return to his wife. Not knowing whether he would return to his children. And not knowing whether he would return to the occupation that he grew to love. Serving others. He had a mentor, a wonderful sergeant in the selective enforcement group, an individual that took Curtis under his wings and tried to teach him everything that could be taught to a 24-year-old rookie police officer. Those rookies face the dangers that veterans do. They're out there apprehending individuals that do awful things to others. Shootings, beatings, thefts, abuse, domestic violence, every single day. 8-hour shifts, 12-hour shifts, seeing the horror of our community day in and day out. It is no surprise that police officers that are out there on the streets must get the training that's necessary to avoid, to prevent injury. Not to allow the injury to take place first, and then you get to do what you need to do. And Curtis, I think, told you, as he was testifying in this particular case, that he attributes his success within the department to that one sergeant that took him under his wings. And Curtis told you that his goal, when he was promoted, to do the same thing for others that sergeant had done for him. He was in patrol for a relatively short period of time. Curtis was a talented police officer. He rose through the ranks pretty quickly. Somehow, this prosecutor thinks that because you rise through the ranks of a law enforcement agency, that somehow you're just some mean individual that likes to go and just face danger and fight and do ugly things. I've been doing this for 37 years, 4 years as a prosecutor.
Objection, improper arguments.
That is not how law enforcement works in this country. As in every profession, you have good officers, you have bad officers. As in every profession, you've got good lawyers and bad lawyers. As in every profession, you have good doctors and bad doctors. But the title of law enforcement does not make you a bad person. Simple man. excelled at the academy. That was recognized from the very beginning. Got the top award when he went to the police academy. I think even some of the officers that came here and testified told you how important it is that first academy training is crucial. You're going out into the streets, and 99.9 of them are going out to the streets as patrolmen. And he went out as a 24-year-old, and within a year and a half, he was in that selective enforcement group. A dangerous position, much more dangerous than even patrolmen. He's going and he's hunting these individuals that are committing robberies, that are committing shootings, that are abusing individuals, torturing individuals in our community. And he learned a great deal in selective enforcement because now the opportunities to go out and get training courses were much more available. He did so well in selective enforcement that he actually started some of the divisions that Tampa Police Department had never known. Tampa Police Department never even had a fugitive squad until Curtis and another officer formed that squad in order to go and arrest some of the most dangerous individuals in our community. It was clear in his career that the upper brass of the Tampa Police Department had the utmost confidence in his training and in his judgment to serve our community, to protect our community. And Curtis told you that as he was going up the ranks, he was actually even pulled into the detective ranks even before being assigned as a detective for 2 and 3 month intervals in order to help the detective division. And he learned a great deal from that division as well. That fugitive group exists today in 2022. How many years from its inception? Curtis obviously wanted to move up in the ranks, not because the ranks made him a control person, a bad person, but because with promotions comes income. He had a wife, 2 kids, going to school almost full time. Yes, the GI Bill was paying for his school. He's trying to make a living for himself and for his family. And he graduated from the University of Tampa, summa cum laude. Can be entire. For the Tampa Police Department to recognize his achievements, they recognize his dedication to our community. They recognize his intelligence in helping that department grow to be a much better department. Of course. And as he moved up the ranks, if you remember, one important part of his career is when he became a homicide detective for 5 years. What exposure did Curtis get when he went into the homicide ranks? One very important one, I will tell you, is that he had daily, weekly contact with the medical examiner's office. As a homicide detective, you go into that office and they're cutting on that body. right there, be present. And as they're cutting on that body, they're dictating the reasons for these injuries, the causes of death, and it is an incredible educational process to the realities of how vulnerable we are, young and old, to violence. You're reminded that in a moment's notice, you can be alive, and in a moment's notice, you can be crippled or dead. It's an experience that most of us in this country, we don't get to know. We just don't get to know it. We're not exposed to it. We can't feel it, we can't touch it, we can't hear it. Curtis Reeves saw it every week. Those experiences don't leave you. They don't vanish. They stay with you. Forever. He was a wonderful homicide detective. With no stone unturned. Homicide detective. Because it does matter. It does matter. Don't let the prosecution tell you that it doesn't matter. Because it does. In his career, probably the most prestigious.
Objection, improper argument.
In his career, he was asked, along with one of the other sergeants, to form the tactical response team for the Tampa Police Department. Let's even think about that responsibility that was given to him and why. The tactical response team was called out for the most dangerous situations that the law enforcement community confronts day in and day out. It was not only a responsibility to actually formulate the blueprint of that team, but more importantly, it was a responsibility to make sure that the men and women that were going to be part of that team were going to have the tools necessary to come home to their husbands and wives and children.
Objection, improper argument.
That's the responsibility that was put on his shoulders. And carrying out that responsibility, he had to go travel the country to make sure that he could find out as much as he could about the risks of danger and how to prevent his fellow officers and himself from getting hurt or getting killed. You know, back in that period of time, I'm sure it wasn't as sophisticated as it's becoming even today. But those same cues, you certainly want to create distance from the person that's attacking you. Why? Because the shorter the distance, the greater the danger. The quicker that individual can strike, cause great bodily harm, or would kill him. The lighting level puts you at a disadvantage. Even Detective Smith told you that. He also told you that noise puts you at a disadvantage in those situations. And why? We get our information from here and from here. And if you're in low lighting situations and noise is loud, you're putting that individual in the greatest of disadvantages. Relative physical capabilities. You've got someone that is big fella, young fella, and you're a 71-year-old individual with all kinds of medical issues. It puts you at a disadvantage, no matter how much training you've had. The training is to prevent. The training is to prevent. And so he formed this tactical unit that in 2022 is still in existence at the Tampa Police Department. 15 years. 15 years he commanded that unit. And not once in his entire 27 years of law enforcement, not once, did Curtis Reeves pull a gun and fire that gun at anyone.
Objection, improper argument.
It's in evidence. 27 years. He's not a trigger-happy, retired police officer. After 27 years, Curtis decides to retire. Old doors close, new doors open. His reputation at the Tampa Police Department was...
Objection, improper argument.
Why do we think that such a large corporation as Bush Entertainment wouldn't want to hire Curtis Reeves? 30 or 40,000 people visiting that amusement park on a daily basis. Why do we think that that responsibility was placed on his shoulders? That responsibility was placed on his shoulders because Curtis Reeves was going to do everything humanly possible to make sure that Bush Entertainment was safe. Curtis told you how he had to change from a law enforcement mind to a corporate mind, because what are corporations concerned with? They don't want anybody hurt at their amusement park. They don't want to get sued by anybody at the amusement park. And they want people to have a happy experience so that they can return. Profit and safety are at the forefront of those corporations. And so, what did Curtis tell you that he did? He just said, oh, well, I'm a police officer. You listen, Captain Curtis Reeves, I don't need to go to any of those courses of yours. I'm going to handle this my way. Is that what he told him? Just the opposite. He went to training after training after training after training in order to make sure that he could develop and know and understand the tools that he was going to need in order to be the best director of security that Busch Gardens had ever had. It was a great job. It's a great corporation. It's a big corporation. You're going to be able to see not only the training that he received in the Tampa Police Department, at least the majority of it, but you're also going to be able to see all of the certificates and all the training that he received from Bush Entertainment, because fortunately it's a corporation, so we were able to get more of those. Because they keep on. For 12 years, he served 12 additional years, 27 at TPD, and now 12 additional years as head of security for Bush Entertainment. We didn't hear anybody coming in here and say, you know, that Curtis, when he was a member of Bush Entertainment as head of security, he was a wreck. He was reckless. He was mean. He was out of control.
Objection, improper argument.
Didn't hear a peep. Because Curtis Reeves was an outstanding head of security for Bush Entertainment. It was a great job, he told me. But unfortunately, his health dictated otherwise. It's the realities of us getting old. We want to keep doing things that we did when we were 30, 40. But we realize when we get up every morning that there's reminders. Reminders of the aging process. Reminders that we want to forget. That we really don't want to confront. That we don't want other people to see. It's that fear if we stop walking, doing the things that we've always done, that we're going to end up in a wheelchair.
Objection, improper argument.
What did Dr. Cohen? Dr. Cohen was not, some expert that we, picked that was traveling giving expert testimony. She was the professor right here in our community, at the University of South Florida, that developed the first aging studies here at USA. Incredible experience throughout the country as far as academic experience. What does she tell you about the aging process and what it does to everyone? We all get there. Some people a little sooner than others. Some people a little later. Some people a little different. But we all get there. And when we get there, it's a scary place. Because we know that it doesn't necessarily get better. We know that as our bodies deteriorate, as Dr. Foley told you, it doesn't happen overnight. It takes many years for that process to take place, and it gets worse. With every single year, it gets worse. When you go to bed at night, and you're reminded of that. You wake up in the morning, and you're reminded of that. And when you pick up your grandchild, you're reminded of that. And so Curtis Reeves being reminded of that day in and day out. Retired from a job that he likewise loved with Bush Entertainment. I think Jennifer told you at one time her dad was invincible. He could do everything. Physically fit, kept in tip-top shape, and loved the outdoors. think she told you that Curtis didn't want to give that up. He may not be able to hunt like he used to. But any glimmer of that hunt was worth whatever pain he was enduring.
Objection, Your Honor, this is improper argument.
It's not a argument, that's what she testified about.
All right, I'll move along.
For those that are hunters, being 10 feet up on a tree may not be viewed by many as really hunting. We're normally 30 feet up in the air because you don't want that game to see you. He makes a big deal that this apparatus, which is so easy to get in and go is some testament to you all that Curtis Reeves is some robust hunter from the year of his 20s. As citizens growing old, as Dr. Cohen has told you, you want to avoid sitting down and withering away. And so he goes on his life now to retire and spend time with his wife, built a new home. These are precious years. They're your golden years. You build a home for retirement. You want to enjoy it with the most important person in your life. Someone that's been by you for 50 plus years. Who better knows Curtis Reeves than Vivian? All his pains, all his aches, all his inabilities. She's right there with him. Unfortunately, she's going through them herself. And so life with your long-lived life and partner, your wife.
Objection, improper sympathy arguments.
Sustained.
So life in your goal can be wonderful and likewise can be painful.
Improper sympathy arguments.
That's affirmed. jury from where I'm at, so I'm going to reposition again.
Matthew Reeves, likewise, talked to you about his experiences throughout the years of his father. In fact, he was the one that had gone to that hunting trip right before this incident occurred. It's important to listen to all the evidence because it matters. Curtis Reeves was an individual that was quickly deteriorating. Dr. Foley told you that. And on January the 13th of 2014, that is exactly the person that walked in to the Cobb Theater with his wife to watch Lone Survivor. It was a matinee on January the 13th of 2014. It was a time for Curtis and Vivian to enjoy what they did often. Go to a midday movie, see what the previews are showing for the future. So you can stay active and go to another movie. And both Vivian and Curtis told you that they were going to meet their son there. And even though Curtis had been on this hunting trip with Matt, it was important for Vivian to spend any time she could with her son Matt. Matt was running late. You remember in the video, we're going to show some videos a little bit later on. They were there in that lobby after they entered. They were in that lobby for some time, wanting to see, whether Matt was going to show up or not. And they knew he was going to show up, but what time was he going to show up? And they eventually went and bought one popcorn and one drink to share. You remember Vivian saying, I brought my little baggie so that I could put popcorn in that baggie and I could eat popcorn from my baggie and Curtis could eat popcorn from the bag. Curtis, as being a retired law enforcement officer, and as he indicated on the stand, being encouraged by a federal statute that encourages retired police officers to carry their guns everywhere. Well, let's think about that. We talked about the wisdom of the law, remember? Why is it that we have a federal statute that encourages retired police officers to be armed at all times? Because those police officers are needed at times to protect our community. They're needed because we live in a violent society, unfortunately. They're needed because we don't know when that next violent episode is going to take place. Had a carrying concealed firearms permit as well. And he had a little itty bitty gun. Not a big one. Not a Glock 44, strapped to the side of his pants. to show how tough he was. With a little gun and a little styrofoam poster that you put in your pocket, that you're encouraged by a federal statute to carry. Remember, this is the same gentleman, he testified to this, that he had never pulled his weapon in the 12 years that he
Objection, improper argument.
his testimony. This is the same gentleman that didn't pull his firearm and shoot anyone in the 12 years that he served as head of security for Bush Entertainment. So they go into Theater 10. By the time they get there, Mr. and Mrs. Oulson are already there. They sit behind Mr. and Mrs. Oulson. Some point in time, commercials are on. Not previews, commercials. Mr. Oulson's playing with his phone. No big deal. No big deal, because at that point in time, it was commercials. The announcement hadn't come on to turn off your phones. And then the announcements come on. And it wasn't just a little bitty announcement. You remember what Mr. Hamilton said, former deputy for Sumter County. Remember what he said? Man, they were playing that announcement to turn off your phone so much that I felt like pulling out my own phone. Because it was over and over and over again to make sure that the experience for everyone in that theater was a good experience. As people, as citizens of this community. Is that not what we all want for each other? The prosecutor calls it, with Mr. Reeves having that light shining on his face and leaning forward and saying, "Sir, could you please turn off your phone because the announcement went on?" He calls that instigation. Again, I almost fell off my bicycle. Instigation. Is that an act of instigating anything? As people, can we not talk to each other and say, "Sir, can you turn off that phone, please?" Is that the prosecution's theory? That somehow that was instigation? Curtis told you, profanity. Fuck you, or fuck off, or fuck off. Fuck off. This 40-year-old man telling this 71-year-old, fuck off. Curtis leans back in his chair, waiting to see if maybe he was going to turn his phone off because he saw Nicole kind of maybe interceding to some extent. And when that wasn't happening, you see him again, "Sir, you leave me no choice, I'm going to have to tell management." Now, let's think about that process. Is that a familiar process that certainly he was accustomed to as head of security for Bush Entertainment? Remember, he told you part of the training that he had received at Bush Entertainment is that, hey, if someone's having a problem with a patron, don't deal with it yourself. You go and get a manager who has the authority to deal with that particular problem, and let the management take care of it. He thinks that's instigation. So I guess everyone at Busch Gardens are instigating because they go and tell management about an unruly individual at their amusement park. It's a darkened theater. Can I tell you how dark it was? Unfortunately, we can't. Whose fault is that? Whose fault is it that we can't tell how dark that theater was? You think Detective Proctor called Rick Escobar on his cell phone and said, "Hey, Rick, come on over, man. We got a shooting over here. I want you to try to preserve whatever you want to preserve." Now you can call Rick Escobar. Oh, Public Defender's Office. You know their number. Think that happened? In our criminal justice system, we rely on law enforcement to do things right. Because it matters. Because if they don't do things right, if they don't preserve evidence, the disadvantage that we face is insurmountable. I think Detective Smith told you, yeah, you're right, Rick, we preserve it not only for the prosecution, but we have to preserve it for the defense as well. And he's telling me over here it doesn't matter. Yeah, got a crappy investigative team out there, Rick. No problem. It doesn't matter. Just listen to me. Listen to him. That's what he's telling you. Just listen to me. Because all that doesn't matter. We'll get into Dr. Knox a little bit. He was an expert in the field of crime scene reconstruction. That's what he teaches. Not only in Jacksonville, but throughout the country. Law enforcement officers from all over. He told you of the dangers of not getting it right. He told you of the dangers of missing those pieces of evidence that can shout out the truth in a criminal investigation. It doesn't matter to the prosecution because they're not being accused. That's why it doesn't matter. But for anyone that's accused, oh, ladies and gentlemen of the jury, it matters. And so Curtis leaves that darkened room, whatever darkened it was, and goes down the road and goes to the manager. And you're going to a little bit see that again. You'll have it in your deliberation room. You'll have a computer, a defense computer and a prosecution computer. You'll be able to look at all the videos and analyze all of that. And I encourage you to please do that. Because it matters. And so you'll see when he was talking to the manager, he was calm, he was polite, he was resting there on the counter. Remember Michelle Simpson was there? And what did Michelle tell you? Yeah, looked over there, there was no signs of any aggravation or hatred or being mad. Because Curtis Reeves has dealt with these situations countless times before. And what did he tell you? He's a mouthy guy. And his perception at that point in time is that's what it was. He was a mouthy guy to get the manager take care of things, and everybody can enjoy the experience again. There's one very important critical piece of evidence that you've seen in the videos. And that is, he leaves the counter, tells the manager exactly where he's at, pointing, I'm up at the very top middle. He comes back, and the first thing that Curtis does when he comes back is what? He grabs the bag of popcorn from video. It's in the video. That's the first thing he does. Do we think, does the evidence show that when he comes back he wants to have any problems with anybody? He wouldn't be grabbing a bag of popcorn, I can tell you that. Because in his training, as he's told me, if he's about to get into something with someone, he better have both of his hands available. That slaps you right in the face. He grabs the popcorn from his wife and he sits down. It is at this time that there's that conversation by Mr. Oulson where he is irate over the fact that Curtis has turned him in. And you got that from Mr. Cummings. You got that from Jane Roy. You got that from Curtis Reeves. This guy is upset that Curtis had gone and told on him with management. And so the only thing that Curtis does is say, look, I see you turned your phone down. You've never gone to tell management. And I see that you were going to put your phone on. That he calls instigating. As human beings in this community, we can't have that kind of conversation. If we can't, God help us all. And so at that moment, he jumps up, that being Mr. Oulson, and turns around, and the profanities and the attack occur. One thing I can tell you is, thank God for that video. I have no idea why he thinks the video is good for him, but thank God that we have that video. As bad as it is, as limited as it is, because it only records on row A, you'll be able to see that and analyze it and do everything that you need to do. It's supposed to be recording the scene of bistro. Thank God we got at least a glimmer of a section in that camera that captured row A. I wish it would have captured row B. Had it captured row B, we wouldn't be here. And what do we see? Somehow, the prosecution tells you that the first attack is a fabrication. We're going to see the videos in just a few seconds. That first attack, Mr. Oulson, is clearly, half his body is in row A. And coincidentally, while his body is in row A, we see this either reflective or illuminating light. You recall what Mr. Koenig said. It was 6 pixels. Rectangle. Madam Clerk, can I see the cell phone? Please. Rectangle. Not square, not round. Rectangle. 6 pixels. Now, could we prove to you all that the illuminating or the reflective light that we're able to see as you see that body coming over onto row A, can we tell you for certain that this is what it is and that it is not Curtis's shoes? We tried. We spent a lot of money, experts flying from all over to get to that cop theater to try to prove with a cell phone in our hands and the actual shoe to try to determine what was that light source. And through no fault of the defense, and through all the fault of the state of Florida, we couldn't do it. Because the cop theater was pretty savvy. They had come in, taken all the hard drives in the middle of the night, on the night of the incident, from the cop theater with a patrolman, and I don't know what he was, with a patrolman there, cordon off Mr. Syllas. My name is Mr. Syllas. I'm here to come get some evidence. Sure, come on in. Go upstairs, take all the evidence. Cop theater flying someone down from Alabama. Here, sir, take it back to Alabama. And within 60 days, not only had they taken the hard drive, remember Mr. Peck, what he said, they had dismantled and taken the entire surveillance system. So when we arrived at the cop theater in the middle of the night, 2 or 3 o'clock in the morning, as Mr. Koenig told you, we couldn't do anything. It was a total waste of time because the responsibility of preserving that evidence was there the evening of January 13, 2014. I will tell you that they had, and you heard the testimony, they had Detective Oulson, they had Detective Papanella, they had Detective Lindsay that had just gone briefly to the hospital. The 3 guys that had started the most respected unit in the Pasco County Sheriff's Office, the cyber crime unit, right there to do everything that we were prevented to do in that theater. They could have done it right there. And for one reason and one reason only, it didn't happen. Because Detective Smith now was assigned as a lead crime scene detective, prestigious position, and he decided that no, nobody was going to do anything. He was going to do it all. Remember, it was the second time ever handling a crime scene investigation on a homicide case. Detective Smith had not even taken the mandatory homicide course. He told you himself. No, hadn't taken that yet. And who was his shadow partner? Proctor. Detective Proctor was the person that was supposed to teach Detective Smith. Now, if that's not the blind leading the blind, I don't know what is. Detective Proctor was cross-examined by me. And he had to admit from this very stand, he didn't want to. How long did it take him to admit? It was radio silence. Detective Proctor, you were not equipped with the knowledge. Detective Proctor, you were not equipped with the knowledge to handle a self-defense case. Because you, Detective Proctor, had only handled one before. And then there was that radio silence. And he finally had to admit, yes, Mr. Escobar, I didn't have to. I didn't have the experience. It took Detective Proctor 8 years to admit that he was not equipped to handle this case. Let's think of, it doesn't matter. It doesn't matter. Could Detective Proctor have told Sergeant Syllas, "Hey, Sarge, I know I wasn't supposed to be assigned to this in the very beginning. Detective Soto was. But I don't have the knowledge." He waits 8 years. Yet before the ladies and gentlemen of the jury, their first degree.
Objection, improper argument.
Sustained.
It matters. We're going to go through the next very important part, because the first attack is as vivid as it can be in that video. Now you remember, you heard testimony that both sides had the FBI. I don't know where their FBI guy is, but my former
Objection,
FBI.
improper argument.
You heard from my FBI guy. Of course, they complained about him as well, that he was costing money. We brought you one of the leading experts in the country in video surveillance, analysis, and enhancement. Mr. Koenig has worked on the most important cases ever in this country. Fortunately, he lives right over here in Pinellas Park now. And what did Mr. Koenig do for us in those videos? He told you about a concept that is very, very important. It's called interpolation, if you remember. And then when you're doing forensics, you've got to make sure that if you're going to enlarge or enhance that video in any way, it's got to be done a certain way. And that's called the pixelation of nearest neighbor. Because if you don't do it that way, there'll be problems. It's not forensically correct. And he told you what happens to big screens when we put things on. And that particular film and video have not been processed correctly with nearest neighbor. Because we don't know what's in the brains of this thing, he told you. We don't know what the algorithms are to make something that's being presented on this screen bigger. Remember we talked about the number of pixels, and through interpolation you could have 76,000 pixels, but if it's improperly interpolated, you can have 6 million, 12 million pixels that were never in that particular film and video to begin with. And guess what? You don't know what they're doing with it because it's proprietary. They don't want to release the secret so that a forensic expert can analyze it and make sure that what you're getting is truly forensically correct.
Objection, improper characterization of the testimony.
Sustained.
And so, what happens? First attack takes place. We brought you that video. We're going to see it in a few minutes. We actually put circles around the two particular areas of focus. The reason that Mr. Koenig did that because he wants our eyes to be focused on that. We did it both ways. We did it without the circles. We did it with the circles. We did it at 200% magnification. We did it at 400% magnification. But he told you one thing that was important. forensically, it was accurate. We're not putting any pixels that weren't there to begin with. And so you're able to see at 25% playback, 50% playback, 200% magnification, 400% magnification. That was a monumental task. So that you would see the truth. Because when you see that archaic video, remember he told you it was worse than the quality of the first TVs that came out in America. When you see that video in a raw form, that first attack happens so quickly that you're not able to focus on it. Obviously, when we're in a court of law, we want you to focus on everything because it matters. Because it matters. Curtis Reeves, with years of his experience, was being attacked. You know, the prosecution came up here and said, if the phone was thrown, remember the left hand? You see how I just picked up this phone, right? The left hand. What hand was Mr. Oulson holding the phone in as he was scrolling? It wasn't my witness. It was his wife, who said Chad had his phone in his left hand. And he was scrolling. He was scrolling. So phone in the left hand. When you see that first attack, that's exactly what happens. What does Miss Turner tell you? Does Miss Turner tell you that the phone's in the right hand? Or does Miss Turner tell you that whatever object she saw, whether it was a thermos or a mug in a darkened theater, was being flipped or thrown with which hand? The hand that Chad Oulson carried his phone. Now somehow, the prosecution wants you to think that somehow it magically got from Mr. Oulson's hand, left hand, and somehow it got in between Curtis Reeves' legs by pure magic. Did they have anybody, forensically or otherwise, come here and tell you that it just floated in the air just out of mystery and it landed in between Mr. Reeves' legs? Take a look at a very important aspect of this video, that first attack. You'll see the body going over, and you'll see a light. At that same time, you see a light. Now, let's talk about that. Remember, we wanted to tell you here today, whether it was the phone or the shoe. We were not allowed to do that through their own fault, not ours. Could it have been the phone, that light that you saw? It could be. Could it be the reflection of his shoes? Of course. Unfortunately, in this case, to make matters worse, because they didn't preserve things as they should have, we've got a shoe that reflects as well. I would have loved Curtis to have sandals that were not reflective. Trust me. But now we've got this particular issue. It doesn't matter whether it was the phone or the shoes. This is the only thing that doesn't matter. Because it's clear that that phone was in between Mr. Reeves' legs. Immediately was seen by Mr. Hamilton after the shot was fired. Immediately. Now let me point out something else. If you say, okay, it's not the phone. And if you say that it's Curtis crossing his legs, it could very well be. Why was that crossed leg at that very moment moving in order to show the reflective characters of that shoe? Why? Why? Because Mr. Oulson, you can see, is coming over the back of his seat towards Curtis. You know, the real problem with the phone issue, the reason that we went there at 2 o'clock in the morning, is that you have camera 11 and camera 12, right? There's a screen of the theater, camera 11, camera 12. These cameras, one camera is recording, the other camera is not recording. There's no rhyme and reason. It is the dinosaur of dinosaurs, as far as surveillance system is concerned. You think to yourself, complicated? Are you kidding me? But this is the problem. If the phone is not illuminated at that time, for whatever reason, it's a darkened theater, are you going to get a light? Are you going to capture that illumination if it's not? This is black. Same thing here. If the phone is being thrown, depending upon all the positions that a phone can be thrown, and that light is not on, are you going to capture the illumination? Six pixels was of interest to us. 6 pixels. We couldn't do what Mr. Knox and Mr. Koenig wanted to do, is to bring that evidence to you for one reason and only one reason. Law enforcement failed to do their job. And so you'll see that there's about 8 seconds between the first attack and what I call the second attack, the popcorn incident. And remember, we had Mr. Knox, we had quite a few witnesses, Mr. Koenig, tell you that what someone is experiencing in that particular chair cannot be captured, that perception cannot be captured exactly from a camera that's 35 feet up in the air. Now, if the camera was right there, to see what you were seeing, to witness what you were seeing, that would be wonderful. We don't have that. And remember, whose perception is it? In whose shoes do we need to step in? The shoes of Curtis Reeves. It was he that was experiencing the attack. It was he that was feeling that particular item hit him on the head. Mr. Reeves, can I have your glasses? Let's hope that I do as well as I did before. It's old man glasses. They move everywhere. I'm not, the arms, the center, you name it. Everywhere. You think that they even looked at this forensically? You think they even used it in their attempted recreation? No, because they didn't have a recreation. We don't even have measurements from them. And does that particular area, something hits that particular area of the glasses, will it hit your eyelid? Something hits that area with some force. Will it cause some injuries to your eyelid? And the prosecutors picked this up. You don't want to touch it too much. I'm touching it. I want you to know the flexibility. You all grabbed it and did everything. Legs, arms, or whatever you want to do with it. Curtis Reeves was hit with a phone. That's without doubt. His own medical expert, his own medical examiner, sat there and said, you can throw a phone at somebody and not have any evidence that it was thrown and hit the face. He said that right
Objection,
up
improper characterization of the evidence.
Sustained.
There's so many variables. There's so many variables. Just because you throw a phone at somebody and it hits them in the head doesn't mean that it's going to split their head open, because we don't know what the force is. We don't know if it hit something before it hit the head. There's a gazillion variables that you have to consider. But we know this. They didn't even think of this. And remember, Detective Conan telling you that he told the tech, forget her name because she didn't have a major part, but let me see if I can quickly find it. Susan Miller. Remember Susan Miller? Koenig tells you, I told Miss Miller that she needed to take a picture of Curtis Reeves' injury to the left side of his face. Susan Miller told you, oh, absolutely not. That was an injury that I saw. Nobody told me that. And I documented it because that's my job as a forensic investigator to do that. And you've got the picture. It's their picture. And you will see that Curtis does have a red mark. Of course, now they had to figure out, oh, well, you know, he rubbed that area, and so now he's fabricating that he was hit with a phone, even though the phone is in between his legs. Sorry, Curtis. That second attack, what are we seeing from seat 9A? If we were in seat 9A, what would we be seeing? We'd be seeing those hands coming at you. That's what we would be seeing if we were in seat 9A. That is what Curtis Reeves would be seeing. Curtis told you that after that first attack, his glasses were a bit askew. Now, you've seen those glasses. Now, if it was my glasses, it'd probably be, you know, because they're so
Objection,
stiff.
improper argument.
My glasses would be stiff.
Objection, still the same argument. Doesn't matter what Mr. Escobar's glasses can do.
Mr. Reeves' glasses are flexible. And so he's seeing those arms coming at him. He told you before that situation, I knew that I had to retrieve my firearm because this guy was coming at him. And Mr. Oulson's very wife was trying to hold him back and couldn't. I want you to think about that. Here's Mrs. Oulson. Her husband has got to be somewhere either directly in front of her, whether she's seated halfway or totally up, or to the right of her. She's using her left arm to hold him back. Now, that's pretty awkward if he was here, but not so awkward if he was right in front. Why would Mrs. Oulson have to hold her own husband back? Because she knows his violent tendencies?
Your Honor, that is completely improper and evidence that is not before this court.
talk a little bit here? Because the screen is in my way, that's why I'm sitting over by the jury so I can see the jury. Ladies and gentlemen of the jury, you'll disregard the last statements made by counsel.
So tell me, what does the evidence show as to why Mrs. Oulson had to place her hand at or around Mr. Oulson's chest? What was she trying to prevent? On his chest. Not, hey dear, calm down. Not, hey dear, calm down. Forensically, Mr. Oulson's hand is in front of his thorax during bloodshed. Miss Oulson's hand is between Mr. Oulson's hand and the chest. What was she trying to prevent? We know that Mr. Oulson wasn't doing this at the time of bloodshed. We know Mr. Oulson wasn't doing this at the time of bloodshed. But a fist is consistent with the evidence. And we're going to look at that photo in just a bit. Curtis knew that he was under...
Object to him using the first name of the defendant.
Surnames, please.
Mr. Reeves was well aware, based upon his training and experience, that he was in a very dangerous situation and that he had to act quickly because the distances between Mr. Oulson and himself were minimal. And that awful things happen in fractions of a second. Fractions of a second. A tragedy took place that day. 2 tragedies. Mr. Oulson died. The family lost a husband. Child lost a father. And Mr. Reeves.
Objection, Your Honor. This is inappropriate whether it's on the state's behalf or on the defendant's behalf.
It was a tragedy. And so what happens thereafter was also a tragedy of insurmountable magnitude. The investigation. We're going to go through every part of that investigation and analyze exactly what evidence you heard and what evidence you didn't hear. Alan Proctor mentor of Aaron Smith, was not supposed to be assigned the lead detective role that day, if you recall. He said Detective Soto was supposed to be assigned, but he was on the other end of the county. And so I guess one of the supervisors said, okay, well, Proctor, you're on. He never even goes into the crime scene before he starts interviewing the first person. He never goes into that scene. He's the lead detective in this case. What do we think about that? And he ends up initially interviewing Corporal Hamilton and his wife. And so if you believe Corporal Hamilton, he will tell you two very important things. Corporal Hamilton will tell you that, number one, he and his wife were interviewed together. Both of them. In other words, in his interview, his wife was there, and in her interview, he was there. And that somehow they had some special procedure going on, Detective Proctor, that before he turned on the recorder, he wanted to determine whether a corporal from the Sumter County Sheriff's Office, what he was going to say. Whether he was of the right mind, I guess. And even Corporal Hamilton told you, you're not supposed to do that. You got to record an interview, record it from the very beginning, and preserve the evidence. Because remember, we're preserving the evidence not just for the prosecution. We're preserving the evidence for everybody. Prosecution, the defense, and most importantly, the community in our system of justice. And Corporal Hamilton, finally on cross-examination, says, yeah, Rick, you're right. Really, what I saw was a silhouette. Well, wait a minute. If all you saw was a silhouette, then what's this bit about, man, you can see 10 seats down, you can see 20 seats down. It's as clear as day during those previews. Why? Why can Corporal Hamilton only see a silhouette? Never see Mr. Reeves. Never see a gun. Because the reality is that it was dark. And why can't I provide you that evidence? Through no fault of our own. It was never preserved. Remember, Mr. Knox told you, light meter, noise meter, it's a no-brainer. Things have been used in investigations forever. But what was told to you here in this particular courtroom that's even more powerful? Do you remember, I believe it was Amy Parrish, if I'm not mistaken, it was the forensic tech that Mr. Michaels was interviewing. And she says, I've got a specialty. My specialty is be able to actually photograph accurately in dark areas. Now that's like a no-brainer, right? You got your forensic investigator right there. You got Detective Aaron Smith right there. You certainly want to, as all the experts have told you, you want to be able to stand in the shoes of Mr. Reeves and capture everything that he was seeing, everything that he was experiencing, and you don't do it. You remember their photography was such a disaster that they had to come back 2 weeks later. Even under Aaron Smith's, remember he told you, my main focus there at the crime scene was I wanted to make sure that they had good photography. Of course, the spotlights that they needed were right outside in the parking lot of the forensic lab truck that they never used. Instead, they brought flashlights. So they bring flashlights, they don't use the equipment that's in the truck, and by all means, let's not use your expert that can actually photograph in the dark and replicate that lighting. So what do we do now in our criminal justice system when that has disappeared through no fault of the defense? but all fault of the government. He says it doesn't matter. You judge for yourself. So Mr. Proctor, Detective Proctor, now Mr. Proctor, he interviews both of those individuals, and clearly, from both of them, they tell him, hey, there's some profanity coming from that silhouette. It's coming back towards Mr. Reeves, and we don't hear a peep from Mr. Reeves. Unrefuted, clearly, profanity. The word, pardon, fuck, used in whatever way at that moment Mr. Oulson was using it towards Mr. Reeves. Fuck! Does that indicate someone is mad? Fuck in a theater! Is that behavior that indicates that someone who's uttering those words has to be totally out of control? Who does that? Remember the environment. What's your environment? We're in a theater. You're supposed to sit down. Enjoy the experience. Watch the preview. Watch the movie. Quiet. It's peaceful. It's relaxing. And someone is standing up in a fit of rage, acting like, I would bet, nobody in this entire room has ever heard before in a theater. Is that a cue? Is that a good cue to understand that the gentleman, if you want to call him that had already attacked you once, is about to attack you again, was out of control? But that's not important to Detective Proctor. Because remember, he doesn't know what a structured interview is. He doesn't know what a structured interview is for a self-defense case. He didn't even want to know what Curtis's experience was in being able to recognize danger, assess that risk, and act accordingly. Please, ladies and gentlemen of the jury, please listen to that interview of Detective Proctor to Curtis Reeves. The proper questioning, according to the experts, would have been, no, you got to know details. Tell us what courses you've taken. Tell us how long you've been tactical. Tell us the experiences that you've had in the past. Because why? Remember the law that we read here? The law tells us that's what we must do. Police officer, jury alike. We must stand in the shoes of the individual that was facing that danger in order to accurately understand their reasonableness. Proctor didn't ask any questions concerning lighting, noise. In fact, he didn't even know exactly where Mr. Reeves was seated. You think he said, hey, Curtis, come, we know you're not a danger because we just put you in the front seat of the patrol car. Come on with us. Let's, sit down here. Let's get the movie theater to put the movie theater at mid-level 1. Do we think, does anybody think that Curtis Reeves would have been a danger under those circumstances? Come on, Curtis, sit over here. Okay, let's put it in mid-level one. Let's get those previews that were playing before. Let's get them going. Let's talk about it. So that not only Mr. Reeves could have explained the circumstances to Mr. Proctor, but even more important, so that Proctor himself could understand that experience. Because if you're not sitting in the shoes of Mr. Reeves, you're not following the law. That's what the law requires. That's what the law demands. And that is the foundation of our Constitution, nationally and in the state of Florida. And so you have a 30-minute conversation before he decides to charge my client. 30-minute conversation where none of the structured interview, as the guard and even their own officers had told you. None of those questions were asked. And you know what was the bomb of the investigation? You know what it was? The bomb of the investigation was that Detective Proctor said, you know, I interviewed Curtis, then I went back and I interviewed Mrs. Reeves, and then I went to the command group, my brass. And I had a discussion with them. And then I went back to Curtis. So thank God for recorders. They're a thing of beauty. Because we had timestamps on it. He didn't realize that. When you report something, you got a timestamp because they put it on the report. This recording ended at such and such. This recording started at such and such. That's how you do it. So now we had timestamps. There were 5 minutes. That's what we did, the timeline. And I kept writing so that the members of the jury could also follow along with that timestamp. 5 minutes between Curtis's last interview, where he had already told Curtis, hey, by the way, Curtis, I'm going to charge you, with second-degree murder. That was that was after the command center. And so I said, hey, here's the timestamp. He was there with his pen, Mr. Proctor. Okay, I'm writing it down, Rick. Yep, I'm writing it down. And we came up with that 5-minute period. I said, uh-oh. That's a problem, Proctor. Did you notice his eyes, his facial expression when it was 5 minutes? I said, now let me tell you this. From Vivian Reeves' interview, you had to go to the command post. Yeah, that was right outside the theater. Okay, so how long did that take you? A minute? Okay, so now we're down to 4 minutes. Right? And in order to get from the command post all the way to the back of the theater, where Mr. Reeves was, that about 3 minutes. You had a 1-minute conversation with your command post as to what you were going to do in the charging of Mr. Reeves? Is that the thoroughness that we expect in our criminal justice system? Is that the thoroughness that our system of justice demands? It doesn't matter. It doesn't matter. Detective Proctor. He admits it was a brief interview with Mr. Reeves. He admits he had absolutely no experience in dealing with self-defense cases. But he makes a decision within a minute with brass. Did he really go to brass? Did he make his decision? Is this a case that he really didn't want to investigate because it wasn't supposed to be assigned to him? Was it just dumped on him? His partner was supposed to be Aaron Smith, crime scene detective, right? He had just gone into the homicide unit in December of 2013. Why are we putting Aaron Smith as a lead crime scene detective when he just joined the homicide side of major crimes in December of 2013? Do we remember the number of police officers that were read out loud before jury selection? Monumental, 130 some witnesses. They had the entire battalion of the Pasco County Sheriff's Office there at the theater. Aaron Smith, that's the guy they choose. If you remember, he started doing interviews first, right? Because he wasn't supposed to be that either. When he first got there, it assigned him to do interviews. Now, did he become crime scene detective because Proctor, the mentor, suggested that that's the position that he should have? Only doing one crime scene investigation before. As a crime scene detective, back as early as the academy, as the lead detective in the case, both of them, back as early as the academy, every single police officer that came before you, I asked that question. Tell me what was told to you as early as the academy. Rick, what was told to me is that I had to be very careful with the issue of contamination, witness contamination. Well, why did they want you to be so careful with that? They wanted me to be so careful with that because it is a big, big problem in that individuals that talk to each other, whether that information is right or wrong, they adopt that information as their own and start believing it as their own. And you can't, they testify, you can't undo it. Because you don't know reality from falsity. And how did we experience that here in this very courtroom? How do we know that happens beyond every expert telling you that came up here, every police officer? How do we know that? Let's talk about an interesting fellow by the name of Mark Turner. Mark Turner was married to Mrs. Turner, right? Joanna. And Mark Turner was called by the prosecution. Now they're saying, again, it's not important contamination. You experienced it here. What did Mark Turner tell you? He said, I came into the theater during the middle of the previews. And when I sat down, Mr. Oulson was standing up. And he was facing Mark Turner. And he was standing up in front of what would have been Vivian Reeves. And he was just standing there. He was playing with his phone, looking at me. And when Mr. Reeves came up, because remember, Mr. Reeves wasn't even there. Mr. Reeves came up the stairs because he had been at the manager's desk. Now let's think about that. This witness that truly believes that Mr. Oulson was standing up, playing with his phone during the entire time that Mr. Reeves was gone. Did you hear that from anybody else? How can a witness believe that? It's worse. And clerk, may I have the pictures of Mr. Reeves? So what he was just using a few examples. Mr. Turner tells you he sees Mr. Reeves coming up the stairs. And he's wearing a tan London fog jacket. Does that look like a tan London fog jacket to you? Does that look like a tan London fog jacket to you? How can Mark Turner believe in his own mind when he was this close to Mr. Reeves as Mr. Reeves passed by? And remember what he says about Mr. Reeves. Mr. Reeves said, "Excuse me." Probably the only thing he got right that day. How can Mr. Turner be so out of space, in orbit, with this testimony? That's what happens. That's what the experts have told you happens. When you have a theater full of people that are in an emotional state, and as you're sitting there, you're hearing bits and pieces from every Tom, Dick, and Harry that is frantic about what just took place. And you're not having a single officer from the battalion that arrived immediately separating people, immediately interviewing people away from each other, and most importantly, also asking them at that very moment, tell me what you have done, who you have talked to, where you have been. And guess what? One more thing that would be really good. Let's get that surveillance camera to see where they
Your Honor, I'd ask the counsel to make the argument from the podium. It's not up at the jury bench.
Let's.
Or at least walk around.
My apologies. I will back up a little bit. Let's get that video still rolling. Let's see where these witnesses were. Let's see who they talked to. Let's get that video from the concession area. Let's get that video from Theater 11. As the experts told you, contamination is one of the worst things that could ever happen at a crime scene, and you cannot rely on those people that have been exposed, and especially in a highly emotional scene like this one. Mark Turner. The prosecutor will tell you it doesn't matter if he was wearing a blue shirt or a London fog. The prosecutor will tell you it doesn't matter if Mr. Oulson was standing the entire time or just a short time. It matters. All of it matters. Notes of conversations were destroyed by Proctor. Remember that 5 minute on, 5 minute off, 5 minute on interviews? Oh yeah, I took notes. Where are they? Destroyed. It took Detective Proctor almost 4 hours to finally go into the crime scene. After he had made his decision to arrest Mr. Reeves, Detective Proctor finally goes into the crime scene. Why go then? You made your decision. Why go then? He said, I've got such faith in Aaron Smith. I've got such faith in Aaron Smith concerning his competency. Did he communicate to Aaron Smith that Mr. Reeves had indicated that, hey, I had seen a blur, think I may have been hit with a phone? Aaron Smith told you, I certainly didn't know about that while I was inside the crime scene, and frankly, I can't even tell you when I learned that allegation. How can the crime scene detective not know that? They're supposed to be partners, working together. You know, I believe that had...
Objection, improper comment as to what the attorney believes.
I will rephrase it. Would Aaron Smith have allowed the tech investigators to pick up this phone had he known that there was an allegation by Mr. Reeves that this phone had been thrown and hit him in the head? I would hope not. But the phone was picked up. It was turned off, which is forensically incorrect, as the expert told you that works for them. Oulson. Not supposed to turn it on. It's turned it off. You're supposed to keep it on, put it on airplane mode. But if you need to get forensic evidence, I'm there, and we can get some things done so that we can extract the DNA. How critical is that to the truth? An allegation that a phone was thrown, someone got hit in the head. How critical is this? What's on with this phone? 3 individuals' DNA are on the black case of this phone. But there's such a mixture of it that we can't tell whose it is. But the important part is that Curtis Reeves is not excluded. How important was this phone on January the 13th of 2014? Does it not matter? And so, Detective Smith is there in that crime scene, and really, what is he doing? What was he doing there for 3 hours? Did he get up there and tell you, hey, this is what I'm doing for 3 hours? The only thing he told you was that, hey, I was interested in getting good pictures, and he screwed that up. Because he had to go 2 weeks later to get more pictures because, the lighting wasn't too good because we had flashlights instead of the spotlights that were in the trunk. What else did Detective Smith do in this case? I can tell you. Right from under his nose, video evidence in this case was seized by a private entity and flown to Alabama. Do you think that when Detective Proctor went into that theater and he looked up and he said, ooh, got some cameras there, that could be wide angle cameras, hey, listen, I want to go see that immediately, certainly before I charge Mr. Reeves. He couldn't do that because he charged Mr. Reeves before he went into the theater. But could he do it after? Say, well, listen, I've already charged him, but let me take a look at that video and let me see what it has, so that if it has something that corroborates Mr. Reeves's testimony, I can maybe uncuff him and say, hey, we're going to take this slow and we're going to really do our job here the way that we're supposed to do it so that innocent people aren't convicted. DNA and video. How many times in America do we see individuals that spend...
Objection, improper argument.
System.
DNA. Can use it today. Can use it 20 years from now. 30 years from now, to find out the truth, with one exception. When you grab a phone and you mess with a phone and you destroy the ability to get DNA in its original form, in its virgin form. What did Detective Smith do to compound the problem? 2 weeks later, still had not been processed for DNA. Detective Proctor tells him, "Hey, Smith, I need to find out whose phone that is. Can you go into evidence and let's open up those packages and let's turn on that phone and see whose phone it was," despite the fact that they already had information from Mrs. Oulson that this was her husband's phone. Who else's phone could it be? Well, wait a minute. Okay, you really need to find out. I get it, detective. Before we open the package, forensic investigators, come here. Let's swab the phone, preserve DNA, then you can do whatever you want with it. Nope. Let's get another glove. Let's grab the phone. Let's turn it on and continue to destroy evidence that was so crucial in this case. Was it total ignorance? Was it? It doesn't matter. These two detectives were a train wreck. And so they have to go to Alabama. Despite the fact that Bousson, this was one of the greatest moments, I think, of this trial for Aaron Smith, because he got up here and he says, "Detective Bousson is my friend. He's a good friend of mine. Detective Bousson is." Like if somehow Detective Bousson was going to protect him. And Detective Bousson, because remember, Mr. Smith had said, "Oh no, it wasn't me. It was Detective Bousson that had to go do something else, and that's why I took over the video process of this case." Detective Bousson came in here under oath, despite the fact that he may be friends with Mr. Smith, and said, "Oh no, didn't happen that way. He was the one that told me, get out of here, I'm handling this." So what do we think about that? Can we have confidence? Can we have confidence in the investigation? Do we need that confidence? Or do we just say, it doesn't matter? Detective Bousson, God bless him. What's ironic about Detective Bousson is that who imaged the hard drives when they finally got their hands on them? Detective Bousson. He told you what he would have done, certainly not giving the cop theater any authority to do anything with that. If he needed search warrants, whatever was needed, he was going to do it, he was going to image it, he was going to preserve it. Now somehow, 15 hard drives, 10 hard drives, impossible to decipher at this point. Because guess what? When they went to Alabama, they never opened the case. They never opened the case. Peck is sued. They never opened the case. Some lawyer, not all lawyers, are trustworthy. Not all doctors are trustworthy. Not all architects are trustworthy. And yet some lawyer that's representing Cobb Theater, and they say, oh, thank you very much. You've given me this case. Oh, you've given me this list. Is that what's in there? Yes, that's what's in there. Okay, well, we're not going to open it. We're just going to take it over to evidence, or we're going to put it in evidence. There could have been 3 kilos of cocaine, nobody would know. Until they opened it. Is that the kind of investigation that we demand in our criminal justice system, to have the confidence to make decisions? Or is that the kind of evidence that the law and the rules and the jury instructions tell us absolutely not? You've got a burden, and you better meet it with evidence that we can feel comfortable and reliable. And so what happens, they come back, and at some point in time, they give this suitcase, whatever it was, locked to Detective Oulson so that he could copy whatever was in it. I think we've talked about Susan Miller and the fact that she had a very limited role, but a very important role here. And that is recognizing that when she looked at Curtis Reeves, you could tell that he had some injury and wanted to document it. John Syllas was the midnight rider. He was the employee that was summoned over to the Cobb Theater in order to seize the hard drive. He did a pretty good job. Approached the deputy there and said, hey, I'm coming to get evidence, and the deputy just let him right through. And remember what Mr. Peck told you? Yeah, that's exactly what he did. And you know what? When I got back from vacation in March, it was a brand new system. Syllas, Peck. We've talked about Dawn Simpson. She had absolutely no interest in anything of this case. She was there at the counter trying to get some posters for her daughter. And she told you without hesitation, when I looked over at Mr. Reeves, he waited patiently. When, I stepped over to the side and I heard that conversation, it was a conversation of a calm man, polite man, not an angry man. Matt Reeves. Likewise, a law enforcement officer for the Tampa Police Department. Who was the first one to come to the aid of Chad Oulson? Matt Reeves. He was the one that caught Matt Reeves. They caught Mr. Oulson. They had summoned another individual. Hey, help me! At that point in time, he didn't know who had a weapon, who didn't have a weapon. But he immediately went to work on Mr. Oulson to try to save his life. And of course, he's a police officer, so he's a liar. So he said, the police officer, he's a liar. What he came here and told you under oath, just a lie. So you know what? Disregard it. That doesn't matter. I submit to you that Matthew Reeves heard his father's cry that day on January the 13th of 2014. What's shocking is that when Detective Smith interviewed him, and he drew a diagram of what was taking place for Detective Smith. What did Detective Smith do with that diagram? Did we see it? Did we see that diagram? No. Detective Smith destroyed a piece of evidence that Matthew Reeves constructed for him. A witness there at the theater at the time of the event. Dr. Michael Knox.
Mr. Escobar, we
Yeah.
gotta take a break.
Yes.
Take 10 minutes, and remember my instructions.
All rise, court is in recess for 10 minutes.
hang on a sec. All right, so what are we looking at? You know,
We've got two small clips.
how much time?
10, 15 minutes.
All right. I'm going to hold you to it because it's already been well past 3 hours. All right, bring them in.
Jurors in the courtroom, Your Honor. You may be seated. All jurors are seated. Present on the floor.
Thank you, Deputy. Ladies and gentlemen, we'll just be a few more minutes, 10, 15 more minutes before we have a lunch break, okay? Just hang in there. Go ahead, Mr. Escobar. I'm going to
Sir.
relocate you.
Sergeant Duff, Deputy Demas, Roy Bedard. Remember their testimony, because it all matters. Roy Bedard, the only use of force expert that was presented to you today, gave you an opinion under oath that absolutely refuted the government's theory of prosecution. Their previous witness. Bruce Koenig. I'm going to show you two small clips that Mr. Koenig provided us so that you could see all the evidence. Matt? Go ahead. May I stop it right there? Who is it? Clear in the other row. Row A. Chad Oulson. What's that? 1, 2, 3, 4, 5, 6. At that very moment. A coincidence? The phone? Or the shoe? If it's the phone, the phone. If it's not the phone, it doesn't matter. That's the one thing that doesn't matter, because where did we find that phone? In between Mr. Reeves' legs, immediately after the shot. They've given you absolutely no evidence as to how it got there. But if it was the shoe, and that leg was moving, it was moving for a reason. Mr. Oulson. First attack. Next one, Matt. Stop right there. The best that we could give you in trying to really feel from seat number 9A what this gentleman was seeing was this. Matt, go through the progression, please. Ladies and gentlemen, this all happened within seconds. The actual shot, 0.72 seconds. Less than a second was the shot. And Roy Bedard, nationally recognized expert in the field of use of force, told you under oath that Mr. Reeves did not fire his weapon in response to the popcorn. Thank you.
Ladies and gentlemen, we're going to go ahead and take a lunch break. Oh, don't do that. We'll take an hour for lunch. It's 2 o'clock. Be back at 3 o'clock if you would, please. And we'll get started again. Any questions? All right. Please remember my instructions during the recess. Don't do any independent research. Don't discuss the facts of the case amongst yourselves or with anyone else. And don't watch any news or media. Thank you.
All rise, court is in recess, 3 o'clock.
And just in case I don't remember, we still got a court exhibit thing issue. I don't know if the state, somebody's video that was used, we were going to get a thumb drive and put that in as a court exhibit during openings. Remember that? I had it in my notes.
That must have been the defense.
Was that the Transcend?
I don't know.
We'll figure it out.
Okay. Because that has not come in.
Okay.
And there was something else that was a court exhibit. But, huh? You didn't? Okay, then it had to be you guys. Let's see. Yeah, we'll make sure we get all that in. The good news is it is a court, every question I had was about a court exhibit, so they don't go back anyways, so. Huh?
I show it was during the defense.
Okay, so whatever that was, all right, if still requested, I mean, I don't know that it's, I don't know. Anything else?
Nothing state.
All right, we'll bring them in. You're using this then? Okay, I'll have to relocate.
Your monitor works.
Oh, okay, and I can see all the jurors.
Right, your monitor works. Don't touch nothing. I got it working.
Thanks. Thanks. Tricia's on standby just in case. Okay, yeah, you can bring them in. Yeah, that'll work fine, because I'll be able to see them and I can see
And
them.
they'll be up on the big board.
Cool.
Sorry.
All right, you're good, you're right. I'm still not as bad as Judge Tepper always was. Oh my gosh, you would start pushing buttons before anything would even happen. She'd push another button and it's like, whoa, stop.
Period in the courtroom, Your Honor.
Okay.
Jurors may be seated. All jurors are present and counted for, Your Honor.
Thank you, Deputy. Ladies and gentlemen, were you all able to abide by my instructions during the recess? All right, we're going to get started again, as I indicated at some point. I don't know if it was yesterday or this morning, but I told you the order of things. Mr. Rosenwasser will now get his rebuttal closing. After that, we'll take a little break, and then we'll be giving you your final instructions. So we're getting there.
This will not be long. At the beginning of the case, in opening arguments, and also during jury selection, we had a conversation about sympathy. So it's important to remind you all about sympathy as we get to the very end of the trial. Now, as you all know, sympathy should never play a part in the justice system. It wouldn't be fair to anybody. We would not want you to find the defendant guilty because you felt bad for the Oulson family. Wouldn't be fair. But in the same vein, we don't want you to find someone not guilty because if for any reason you feel bad for the Reeves family. Now, sympathy, of course, is a human emotion, but it really does have no part in the criminal justice system. In fact, there's an instruction that Judge Barthle is going to read to you, and I'm just going to read it to you very quickly just to show you that it's in there. It says, your verdict should not be influenced by feelings of prejudice, bias, or sympathy. Your verdict must be based on the evidence and on the law contained in these instructions. So I know it goes without saying, and I almost feel bad saying it, I know that you won't let sympathy affect the verdict. You also know that the judge is responsible for any sentencing. You should not let that factor into your deliberations at all. You are the fact finders and the law appliers. Any sentencing issue is for the judge. Now, sometimes in trials what happens is this. Sometimes when you walk back in, and I know this might sound silly, but sometimes when you walk back in, someone might be in the audience. Might be a family member, might be a friend of either side. They might give you a smile or a glance, or sometimes people look away. Obviously, that does not have any impact on your deliberation. if any of us looked over and smiled, or at some point we looked like we weren't happy, the same for the defense table, has no bearing on the case. It would kind of be like putting it into the shiny object portion. It really doesn't mean anything at all in this particular case. So it's just very important for you to remember that. There were some comments that were made during defense counsel's closing that I do want to address. And then afterwards, we're going to fairly quickly just go through some things on the video, and I'm going to sit down. A couple very minor points, quickly address them. Defense counsel in his closing argument talked about DNA, how the defendant here could not be excluded. Well, there was a stipulation that was read, and really what the stipulation said, one part of it was there was not enough DNA on the phone to determine anything. Couldn't be included, couldn't be excluded, didn't mean anything. There just wasn't enough DNA on there. Doesn't really matter, because we all know based on the evidence, this phone was never thrown. The reason that the phone was where it was because either of two things happened, and no one knows. But the reasonable inference from the evidence is that when he reached over for the popcorn, it fell, or at the time he was shot, it fell. We know for a fact, though, with 100% certainty, that at no time was that phone ever used as a weapon, wasn't used to punch the defendant, and certainly was never thrown at the defendant. We know that for a fact because why? Because there's absolutely no injury. And even if that was some miracle, there's not a single person that saw an attack with a phone in the entire case, including his wife. We know with 100% certainty there was no phone at issue. The reason it's on the ground is because it was dropped at some point in time. That's it. There was another mention in closing argument from the defense counsel about how if you have a phone, you have this phone, it should be placed into airplane mode. Here's when that's important. If a phone is being searched for videos or for photos or for text messages, the content, you can save the content by putting the phone in airplane mode, or you put it into a certain box. If you're going to be looking at it for DNA, which in this case doesn't matter because it's just a shiny object, but if you were looking at it for DNA, you don't care if the phone's on or off. That's just a shiny object. Doesn't mean a single thing. Defense counsel talked about the timing of certain things, and we'll go through it on the video. But he mentioned that Nicole Oulson stood up, and prior to the popcorn being thrown, she had her hand on Chad Oulson and she was holding him back. Well, how do we know that's not true, that that's not the proper timing in this case? Number one, it's not on video. Number two, we go back to this point about eyewitnesses. Not a single person testified that there was a struggle where Nicole Oulson was trying to hold back a charging Chad Oulson. Who didn't see that? There's nobody in the entire case that saw that happening. And if it happened right in front of who? Vivian Reeves, Jane Roy. Nobody saw that. Why? Because that never, ever happened. You keep going back to the defendant starting it and the defendant ending it and a popcorn toss. And that really is this case, unfortunately, in the most simplest of terms. That's just what happened. It's sad, but that's exactly what happened. Defense counsel brought up, and it's kind of the reason why I brought sympathy up with you, all these things that the defendant had done. But it almost seems like the argument is this. Because in his past, he did these things, you know what? We shouldn't be having a trial. We shouldn't have you here as jurors to even discuss the fact that Chad Oulson was unlawfully killed. He's excused from killing someone based on his background, training, and experience. And if you think about that, it's really an unbelievable argument. Now, in theory, we have laws in the United States that apply to every single person, in theory. From the President of the United States all the way down to Pasco County, every single one of us is bound by the same laws. You can't unlawfully kill somebody. It doesn't matter if you're the head of security at some point in your life of Busch Gardens. It doesn't matter if you're a police officer. It doesn't matter if you're a police officer today. Police officers are not given free passes. Nobody is ever above the law. Ever. You never start out one step ahead. Ever. It's as if to say, you know what? Chad Oulson's life was meaningless because he graduated summa cum laude. Chad Oulson's life is meaningless because he started the SWAT team that they use today. Chad Oulson's life is meaningless because of the things he did at the Tampa Police Department. His life is meaningless. We shouldn't be here. That's sort of what's being said. Nobody ever starts above the law. Ever. Doesn't matter who you are, doesn't matter what job you have, it doesn't matter how much money you make. We're all judged equally under the law, no matter what. He killed another human being in a crowded movie theater next to his wife for no reason. Nobody should care what he did in his past. It's what he did on January 13th of 2014. He killed another man in a movie theater. Defense counsel talked about this first attack happening so quickly. It happened so quickly, he didn't even mention it to Detective Proctor, right? It's because it never happened. There was a conversation about Detective Proctor making a mistake because he never, ever had investigated a self-defense case. And I mean this as almost sarcastically as I'm going to say it. If he never investigated another case after that, he still has never investigated a self-defense case, because this is not a self-defense case. We're going to quickly go through the video. It's kind of like the cross-examination with the defendant.
May I just dim the lights for this?
Sure.
And when you get the computers, in the back, the MOV files are the ones you can open with QuickTime. Of course. One.
Yep.
There you go. Got the magic finger, apparently. Everybody sees what I'm doing? Here's the beginning, where we were talking about the reflection being the shoe. At no time was the reflection ever the cell phone. It has always been the shoe. It's not a coincidence. This is the very first frame where you can see the defendant's shoe as he's walking. It's going to go back and forth. Always motion. That's the shoe. Now, defense counsel talked about all these experts they were trying to get and all the money they were spending. They saved a lot of money just by looking at the video because it's very obvious that it was the shoe. Okay, what's the importance of this? The importance of this is the defendant and his wife coming into the theater. And it's really nothing in that they're just walking in the theater, but the camera's able to pick them up because it's within the motion sensor area. Okay, that's the importance of just watching the very beginning. An almost insignificant event of two people sitting down triggers the motion-activated camera. Now, when you're looking at this, if you can look, you see the defendant is on the left side, and this is Vivian Reeves on the right side. In front of Curtis Reeves, you can see this is Nicole Oulson. So they sit down, Nicole Oulson is already there. Here's the next time we see the shoe. He's crossing his right leg over his left leg. There's the shoe. Okay? We don't have multiple cell phones. Nothing's happening. This is obviously his shoe. No speculation whatsoever that a phone was ever in play. Here he is leaning all the way in. Back appears to be fine there. Getting up to go to the manager. Now, for the next 3 minutes, he's at the manager's desk. He's returning back. Lo and behold, legs moving, there's a flash of light. No cell phone being thrown there, flash of light. And we don't need an expert to tell us that. Once the defendant comes back into the theater, as Derek Friedoff indicates, once again there's bickering. Chad Oulson turns around in his seat. Coincidence? The defendant's right leg is moving. As he moves forward, you see the light. Absolutely, with 100% certainty, his shoes. And as we indicated, there is absolutely no way at this moment that a phone is being thrown as he goes forward. And his explanation for not reacting, not putting his hands up to his head, not exclaiming anything, not having any injuries, was because he took karate some time ago. Now, what did the defendant indicate? Now remember, there's this first attack. There is no first attack. However, what the defendant indicated is that during this blue screen time, and remember we had a conversation up here, he's like, well, the camera doesn't hit row B. This camera is not picking anything up at all because there's not any type of significant event that is being recorded. So when the defendant wants you to believe that during this period of non-recording, Nicole Oulson is fighting back with Chad, who's a raging lunatic, it's not picked up by the video because it's not happening, because there was no phone thrown. It's an absolutely made-up event that didn't take place. Now, the other important part of this, I'll tell you in a second. So now he's reaching over, he throws the popcorn. The popcorn has now hit him. After the popcorn has hit him, the defendant is going forward. Now, there's another flash down here, which is obviously his shoe. He has been hit with the popcorn. The gun's at the hip. He reaches forward, and he shoots him. Popcorn, thrusts forward, and shoots. Now, Roy Bedard. Let's talk about Roy Bedard real quick. Roy Bedard did testify 2 years ago in a case that I prosecuted. And what Roy Bedard does is he travels around the country, testifies for the state, testifies for the defense, and he educates juries on self-defense. Now, the unlogical or the illogical leap is that because Roy Bedard didn't testify for the state in this case, that means the defendant's not guilty. That's the extremely illogical leap. Because if you took that position, anytime somehow Roy Bedard becomes the person that is critical for any case. So for the rest of my entire career as a prosecutor, if Roy Bedard testifies in a case where I'm the prosecutor and he's on the defense side, I guess I should just hang it up, right? I'll just jump off the case then, because if Roy Bedard's on the other side, that means that person's not guilty. That's how illogical that argument is. Now, we know, based on the evidence, that this was, unfortunately, about popcorn because of the defendant's statement. But let's, for just a second, let's suspend the reality, because that's what the defense wants you to do, is suspend the reality that it was about the popcorn, and that it wasn't. What that means is, if you want to believe what Roy Bedard stated, and he wasn't asked, who knows if he knows anything about the defendant's statement about popcorn hitting him? We don't know, no one asked that question. We don't know where that information came from that he testified to. But let's just suspend reality because we know the defendant made that statement. If he started the process of shooting and killing Chad Oulson, think about this. It's worse for him. Because what's happening right here? There's not a single thing that's happening here. So he made the decision to kill him for absolutely no reason. But in reality, that's not true. You have to suspend the reality. Because what happened was, after the shot, he made it clear why he did it. He had an explosive moment of anger. He was angry because of what happened with Chad. Because Chad was standing up for himself, was saying things about texting his daughter. He reached over, he grabbed the popcorn, and he threw it on him. And when he had his hand coming back, that's when he was shot. He was not about to attack him. There wasn't any imminent threat of death to the defendant. Wasn't any imminent threat of great bodily harm. I'm not going to go through all the jury instructions with you. That is this case. That is really this case. That's the end of it. There was a question asked by defense counsel of Detective Proctor. There's a series of questions. And when I heard them, I thought, that was a really great set of questions, but not for Detective Proctor. And I wrote them down, so I'm going to give you a version of it. If it's not exact, it's not exact. But it was a really good set of questions. But when I say them, I want you to think about it from the defendant's point of view, not from Detective Proctor's point of view. And this is what the questions were. Is it important to be right and accurate in a homicide? Dealing in possibilities is dangerous in criminal court because a man's life is in your hands. And that's really powerful. And that's exactly what was at issue in this particular case. The defendant here had a man's life in his hands in a movie theater on January 13th of 2014. Chad Oulson went to the movies and he never came out of that movie theater. His life was taken from him. It was an unjust shooting. He didn't deserve it. Not under that fact pattern in that theater on that day. We come back full circle. The defendant started it. The defendant ended it. And yes, unfortunately, a man was killed because popcorn was tossed. The defendant is guilty of either murder in the second degree or manslaughter. And he is guilty of aggravated battery as well. Thank you.
Thank you, Mr. Rosenwasser. Yeah, just push it back, that's fine. Great. All right, ladies and gentlemen, I know that was pretty quick. I do want to, I got to let you go for a short break. The lawyers and myself have a little bit more work to go over shortly before we begin your instructions, okay? So go ahead and take about probably 15 minutes, maybe a little longer, but Deputy Martin will come and get you when we're ready. Probably at least 15 minutes, and then we'll be ready to start with instructions, okay? Remember my instructions during the recess. All right, thank you.
All rise for the recess of the jurors for 15 minutes. Yeah. Jury is out.
Are you gonna, you're not using it anymore, right? Yeah, if you, it doesn't matter. Well, I can't see, yeah, I can't see the fence, so, yeah, if you could go ahead. Go ahead, uh-huh.
what? You're welcome, like, everyone can.
Cuando todo parece volverse inestable, Iberdrola presenta.
Yeah, that's fine, Christy, okay.
All right, counsel, I have in my hands what I believe to be the final version of the instructions. I want to go through them. I'm not going to read them line for line. I'll do that in a few minutes when the jury's here. But I'm going to reference each page according to what it is, and I'm going to be looking at the page. I haven't seen any typos or issues or problems, but let's go through them one more time. Make sure that we're all have the same order. All right, so I'm going to start with the first page is Introduction to Final Instructions, one sentence instruction. Same with Statement of Charge. We've got murder in the second degree and aggravated battery. Third page is Intro to Homicide. We got second degree murder at the top, and then all of that. Is there any questions about the body of that?
None from the state.
Okay. So that leads into the murder in the second degree instruction.
Objection from the state.
Okay, that looks good, that one. I don't see anything there. And that is followed by possession of a firearm and discharge. That's got all of the language in there. Okay, so then we go to the lesser 3.4 lessers, and the lesser indicated is in murder in the second degree is manslaughter.
I just saw the page that we don't have.
What?
I don't think we have, after aggravated battery, the lesser page that says the lesser of
Oh,
aggravated battery.
okay.
felony battery,
I knew, that's been nagging at me, you're right. I knew there was another lesser somewhere of this one. Okay, so that's 3.4, and we've got,
We'll have to have someone make that one up.
yeah, we'll need that. All right, so that's going to go after the aggravated battery anyway. So manslaughter, that's followed by the manslaughter instruction, which is 2021 version.
No objections.
Good on that one? All right, and that is followed by aggravation of a felony with firearm.
No objections.
Okay. Then we have justifiable use of deadly force. And you guys have all gone over that extensively, I know.
Correct, state has no objections to this.
Okay. All right, the next one is battery, bat 65. And that looks, no objections on that one.
Correct.
All right, and then we've got the aggravated battery, of Chad.
That's Nicole Oulson.
The one that I have is,
Oh, you learned on the...
So Chad is part of the justifiable.
right,
Right. I thought we were there. Okay, so that's 65, then that aggravated battery.
Right.
Okay.
and then another ag bat with Nicole.
Yes.
Okay. And yeah, we need the lessers.
After that aggravated battery is the possession of firearm and discharge causing great bodily harm.
Okay, so that sticks with the ag bat.
Then after that, we need the lesser.
Then after that is the lesser.
Mr. Funderburg, I think, you
Okay. So that'll be felony battery and battery. Correct, okay. So we have both of those. We just need the lesser. Any problem with the felony battery or the battery?
No, Your Honor.
All right.
No, Your Honor.
Then comes the transferred intent, and you both worked on that one, so it's, should be good.
Yes, Judge.
All right. Then plea of not guilty. That shouldn't have had any changes to it. It all looks good.
We added shall, we all agree. on
Oh,
that.
that's right, yeah.
That's the instruction.
Yeah, correct. All right, and weighing the evidence, looks like we've got a total of 6 there. That all looks appropriate.
We have no objection to the 6, I don't think the defense did. We-
Yeah, you talked about those.
Discuss those yesterday.
We've got number, quality, then law enforcement witness, expert witness, defendant witness, proper to talk to lawyer, and then your own conclusion. All right. Defendant's statements is in there.
In my copy, I don't know what the court has, I have him and her.
I do too. Anybody worried about that?
I'm not. If you want to make it perfect, we take out the first.
Right. And take out the brackets.
Let's do that.
Okay,
I'll get Mr. Fuller.
okay. Rules for deliberation. You know, we could really take out, well, just leave it, number 7.
Yeah,
But-
we could take that. I mean, no one would probably think about it because it didn't happen.
Right, but,
It would be better to take it out, I think.
yeah,
But I don't
Yeah.
think that's part of their note-taking, or not, I understand what, I know what it means legally, but I would just, there's no harm in leaving it in.
there, I don't see any harm in leaving it.
I don't either.
Okay, I'm good with it. And then there's not much you can talk about on the cautionary instruction. Single defendant, multiple counts. Would that, it doesn't matter. I was gonna say that might do better in front of the cautionary instruction, but,
I don't know where it goes in the book, wherever the order is in the book. is
yeah,
where it should
I
go.
know. I think it goes before the cautionary. Usually the cautionary and the last, those are the last 2, but I may be wrong.
Well, Your Honor, on single count, now that I look at it, because this is an issue of transfer intent, and then transfer intent which cuts the other way, if it's justifiable, the use of force, must find Mr. Reeves not guilty of the count involving Mrs. Oulson. The last line in single defendant, multiple counts says the finding of guilty or not guilty as to one crime must not affect your verdict as to the other crime charge. So, I mean, that seems to imply, if somebody reads this, that there may be a conflict in getting the instruction that.
Yeah, the transferred intent.
Yes, Judge.
I don't think so.
Well,
Only because, let's just say hypothetically that they were going to go guilty on one. Then they can say not guilty on the aggravated battery.
Right.
And if it does come back, then we know we just have a legally inconsistent
Right.
verdict, and then you know what you have.
Right.
There's no
I
argument
think
there.
the only other option I would think, you'd almost have to say unless you find that transferred intent applies, but,
Then they're just.
right, that's getting, I'm okay with leaving it just as it is, and if there's an inconsistent verdict,
Legally inconsistent.
legally inconsistent,
so
it'll be adjusted accordingly.
I understand we're requesting that that line be struck. I understand the court's ruling, but that's what we're requesting. Certainly, if it ends applicable to it, must be considered separately in a separate verdict return as to each. I think that says it. I think, without putting the language of transferred intent, since we already have that instruction, that last sentence, if that's struck, that
Yeah, but, I mean, just think though, that if that would totally not apply if they found well, I don't know. You know, they could find
Well,
not
but then-
guilty as to,
Right, that's the issue. Let's say they check, let's just say they find the second degree murder was justifiable. Then they're going to make a finding that Mr. Reeves is guilty, but for some other reason other than transfer intent. I mean, I don't know.
It would be a legally inconsistent word,
Right,
so we couldn't do it.
I
right,
understand.
right. That's
It's practical.
uncontroverted.
Okay.
If that's how it, if they find it to be justifiable, then they can't find guilty on the ag bat.
I know.
So, that's on the
That's our
record.
objection.
Okay, I get it. I think if we change this one, we're asking for a lot of confusion. And I know that's not typically a reason not to, but I think it's a pretty good reason not to, with the understanding that we have a perfectly lawful remedy should that situation arise. All right, so anybody find where they're at? Should the cautionary instruction be? I don't think it really matters, but it just, I don't know, I seem to think remember it going before the submitting.
Because submitting is in closing, so definitely before that one.
Oh, yeah, but it seems like that's. I don't know what I'm saying is, I don't know if it goes before the single defendant, it just seems to flow better with the final, yeah,
It goes after, I found it.
okay, good.
After the questionnaire instruction, that's when you go through the verdict form.
Oh, it doesn't say that on there. Oh, I would have been lost on that.
You know what, we're missing that page.
Yeah, where is that?
3.12, we're missing that whole page.
Okay.
3.12,
What is that?
verdict. When the judge reads how the verdict form goes.
Yeah,
Must have left that out of the package.
Yeah, we need that whole one.
yeah, I would have been lost there for a minute. Because it says read verdict now. Read verdict form.
Yeah, so we need that page, and then the verdict form we all have agreed on.
Okay.
And after that, those single defendant multiple counts,
Yes.
and then submit the case to the jury.
Okay.
So we have, maybe 3 pages we need to correct.
All right, so we've got that one instruction needs to go in there. Is it just 3? We have we're not doing anything with that single defendant, multiple counts. We need the lesser for ag bat, and what else?
Page we're missing, I'll read the verse.
Right, that's 2.
We're taking out the her.
Oh, that's right, thank you. All right, and who's got these on their computer?
I think Mr. Thunderberg is doing some of
Okay.
We can, Judge Wild, we can make a very quick motion that we're going to make as well. It's, we're going to renew our motion for judgment of acquittal.
Okay.
Same arguments that the government has failed at this point to present any evidence whatsoever to refute the justifiable use of deadly force in this case for Mr. Reeves.
All right,
And specifically with the instructions that everybody has approved, they have failed to meet that burden.
any response?
At this stage, the court has heard all the evidence. There's ample evidence to support this case being submitted to the jury. We have proven all the elements for second-degree murder. We've had witnesses that have indicated that the defendant appeared grumpy. We have sufficient evidence that there's a significant period of time between the time that the defendant first had contact with Chad Oulson up to the point of the time of the shooting, sufficient to demonstrate enough time to develop ill will, hatred, spite, or evil intent, coupled with the defendant stating after the shot, worse the effect of a cop in my face. With respect to the aggravated battery, under the transfer intent doctrine, we have presented sufficient evidence for that case to go to the jury as well, as the defendant did intention to shoot Chad Oulson. Oulson's hand was in front of his chest at the time of the shooting, and she did in fact suffer great bodily harm, permanent disfigurement, permanent disability, or the defendant did use a deadly weapon, which would be a firearm.
Your Honor, if I may just be excused, let me go see if Mr. Funderburg can print up this introduction to final instructions that was left out of the packet that was provided to us by the state.
Okay.
I'll be back in a minute.
All right. I'm gonna deny the motion for judgment of acquittal. I find that the state has provided evidence to overcome the argument of the defense. Thank you. All right, so.
Judge, the only other thing that we probably ought to do is approach.
Відімкнути Росію від платіжної системи SWIFT – одна з найвагоміших економічних санкцій, що її від європейських країн очікує Україна. Втім, одразу кілька держав таке рішення блокують. Серед них до останнього була і Німеччина. Наша кореспондентка у Берліні Наталія Фібріх готова говорити про це докладніше. Маємо її на зв'язку.
Ladies and gentlemen in the audience, in a few minutes, we're going to start jury instructions. During the jury instructions, no one will be allowed to enter or leave. So be comfortable or go ahead and go now, because you won't be permitted to come and go during the instructions. Thank you. How's it going?
Yeah, I'm gonna go check with him now. I just
When we have the lesser one that goes before the aggravated battery, that will make it, I knew that didn't flow right. You went right from the ag bat that hooks with the justifiable use to Nicole's ag bat. It just didn't, I knew there was something missing, so that'll make it much better.
See what the time of the
Okay. Connie's on standby to make all the copies, so. Corporal? the last. And if you guys want to look at this. possession of a firearm and discharge, excuse me, when there are lessers for manslaughter, of second degree is manslaughter, then the manslaughter instruction, then aggravation of a felony by carrying a firearm, then justifiable use of deadly force, BAT 65, ag bat of Chad, then when there are lessers for the aggravated battery of Nicole, felony battery and battery, then the that needs to go behind, no, that's right, so,
No, there's an aggravated battery for.
right, that goes first, right.
That goes first.
Okay, so we do have two ag bats in a row
There's an aggravated battery that,
of Chad,
Right. Well,
right.
what you do is, I think when you're reading the justifiable use of deadly force, when you get to that crime where it says
Does it have a spot in there?
when you, like, right after you read the crime, to commit the felony offense of battery on a person 65 years of age or older, then I think you say that the court will now instruct you as to the elements of that crime.
Okay, that makes sense.
And then you read the elements for that crime.
And then the
Then
same,
you go back to the justifiable use of deadly force instruction, and then after you read the aggravated battery, then you say, I'll now read to the elements of aggravated battery.
okay, fair enough?
yes, Judge.
You good with that? All right. So, so after the ag bat
On
with the,
Reeves,
yeah,
Then there's the,
the ag bat of Nicole,
yes, Judge.
So
And-
after the aggravated, well, yes, I know we're going in order, but after the reading of the aggravated battery, you go back to the
right,
justifiable.
I'll finish that, and then I'll skip those two and go straight to the ag bat of Nicole, and then after that, there will be lessers of that ag bat, which are,
There's the 1020 life instruction after the aggravated battery.
oh, I don't have that in my package, do I?
You did-
There it is, yeah, it was out of order, okay, so, that goes, the 1020 life goes right after the ag bat,
Yes,
Correct.
Nicole's ag bat, and then when there are lessers,
Right.
okay. And then those lessers are instructed,
Felony battery and battery.
yep, then transferred intent, plea of not guilty, weighing the evidence, defendant's statements, rules for deliberation, single defendant, multiple counts, cautionary instruction, verdict, and submitting case to jury.
The single defendant multiple counts goes after you go through the verdict form.
Okay. Okay. So, let's see. Cautionary, yeah, cautionary comes
instruction,
before
verdict.
verdict. Yep, you're right, it does. Then single, then submitting case to jury, okay. Verdict, yep, right. All right. So, anybody have any comments, questions, problems?
I think just for the record, the state will say that the state's reviewed all the jury instructions and we have no objection to them.
Okay,
No objection for the defense.
all right, very good. Then, when we bring them back, I'll begin instructing them. They'll each have a copy, as will all of you. I need 16 copies. Why? Oh, court reporter, clerk, okay. So I need a total of 19, so that'd be 18 copies, right? We got one? Okay. I'll instruct them. At the end of the instructions, I'll call you all up and ask you if I read them as we agreed, and if there's any objections that aren't of record, you'll step back, then I'll release the alternates, and then they'll go.
Or you want to do the computers?
Oh, yeah.
When you talk about the jury, the evidence will go back with you and.
Yeah.
We have.
The deputy clerk will be sure that all of the items and evidence are gathered together along with the verdict form. And I'll tell them then.
And that the exhibits on there are preloaded.
Uh-huh.
What's there, so they don't have to.
Right. Look for them. Just take anything out of, it's already on there, right? Okay.
And Judge, what evidence is staying back?
The gun, yeah. All right.
Your Honor, spoke the jury up, if I may, that the videos from the defense have submitted, the videos that the state has submitted, along with the audio recording, there are other items of evidence that are not on them. So in other words, if they want to look at photographs, for instance, that were entered into evidence, they wouldn't find that on the laptop.
Okay.
They're just a video and just the audio recording of the interview. So they have to know that to find something else, they're going to have the photos and other items back there, with the exception of the firearm that you're going to talk to them about.
Mm-hmm. Only the videos and the audio statement.
Of Mr. Reeves.
Interview of Mr. Reeves.
And that interview's on both.
Okay.
And Judge, they need to check all that unless they.
Yeah. Well, you guys will check the evidence before it goes back, right? Or look through it?
Yes, Your Honor.
Tammy,
Somewhat
were you able to go
order.
through that list?
Yes.
So that's.
Yes and no.
Yes and no?
Uh, Are you giving it to him in a box?
Yes, Judge, it's on the box.
All right.
It's somewhat in order of each thing. These have the big photos.
Okay, so I'm going to say photos and the other exhibits will be given to you in the box, provided to you. Okay. All right, so while she's making those copies, if anybody needs to use the restroom, which I'm going to go real quick, it'll take just a few minutes and then we'll be ready to go.
I just need to go once. I mean, I got some from Mark, but now I got questions, so I'm like, I'll wait. Okay.
Yes. Oh, okay.
Detective Smith told me that the batteries,
Uh-huh.
because of their age, I mean, they're very low.
Excuse me. Oh, yeah. Good. Thank you, Connie. Have a good weekend. Thanks. All right. Verdict forms, yeah, right here. You can get them, Tina. They're not answering.
Jurors in the courtroom, Your Honor.
Very good. Thank you, Deputy. Thank you, ladies and gentlemen. Deputy Martin's about to hand you all copies of the instructions, and I'll get started. Thank you all for returning. Were you all able to abide by my instructions during that last recess? All right, thank you. right. Members of the jury, I thank you for your attention during this trial. Please pay attention to the instructions I am about to give you. Statement of charge. Curtis Reeves, the defendant in this case, has been accused of the crimes of murder in the second degree and aggravated battery. Introduction to homicide. Curtis Reeves is accused of second-degree murder. Murder in the second degree includes the lesser crime of manslaughter, which is unlawful. However, a killing that was excusable or that was committed by the justifiable use of deadly force is lawful. If you find Chad Oulson was killed by Curtis Reeves, you will then consider the circumstances surrounding the killing in deciding if the killing was murder in the second degree or manslaughter, or whether the killing was excusable or resulted from justifiable use of deadly force. Justifiable homicide. The killing of a human being is justifiable homicide and lawful if necessarily done while resisting an attempt to murder or commit a felony upon the defendant, or to commit a felony in any dwelling house in which the defendant was at the time of the killing. Excusable homicide. The killing of a human being is excusable and therefore lawful under any one of the following three circumstances. Excuse me. 1, when the killing is committed by accident and misfortune in doing any lawful act by lawful means with usual ordinary caution and without any unlawful intent, or 2, when the killing occurs by accident and misfortune in the heat of passion upon any sudden and sufficient provocation, or 3, when the killing is committed by accident and misfortune resulting from a sudden combat, if a dangerous weapon is not used and the killing is not done in a cruel or unusual manner. A dangerous weapon is any object that will likely cause death or great bodily harm if used in the ordinary and usual manner contemplated by its design and construction. An object not designed to inflict bodily harm may nonetheless be a dangerous weapon if it was used in a manner likely to cause death or great bodily harm. Great bodily harm means great as distinguished from slight, trivial, minor, or moderate harm, and as such does not include mere bruises. I now instruct you on the circumstances that must be proved before Curtis Reeves may be found guilty of murder in the second degree or any lesser included crime. Murder in the second degree. To prove the crime of second-degree murder, the state must prove the following three elements beyond a reasonable doubt. 1, Chad Oulson is dead. 2, the death was caused by the criminal act of Curtis Reeves. 3, there was an unlawful killing of Chad Oulson by an act eminently dangerous to another and demonstrating a depraved mind without regard for human life. An act includes a series of related actions arising from and performed pursuant to a single design or purpose. An act is eminently dangerous to another and demonstrating a depraved mind if it is an act or series of acts that 1, a person of ordinary judgment would know is reasonably certain to kill or do serious bodily injury to another, and 2, is done from ill will, hatred, spite, or an evil intent, and 3, is of such a nature that the act itself indicates an indifference to human life. In order to convict of second-degree murder, it is not necessary for the state to prove the defendant had an intent to cause death. Possession of a firearm and discharge causing great bodily harm or death. If you find that Curtis Reeves committed murder in the second degree, and you also find beyond a reasonable doubt that during the commission of the crime, he discharged a firearm and in doing so caused great bodily harm or the death of Chad Oulson, you should find Curtis Reeves guilty of murder in the second degree with discharge of a firearm causing great bodily harm or death. Great bodily harm means great as distinguished from slight, trivial, minor, or moderate harm, and as such does not include mere bruises. If you find that Curtis Reeves committed murder in the second degree, and you also find beyond a reasonable doubt that during the commission of the crime he discharged a firearm, you should find Curtis Reeves guilty of murder in the second degree with discharge of a firearm. If you find that Curtis Reeves committed murder in the second degree, and you also find beyond a reasonable doubt that during the commission of the crime he actually possessed a firearm, you should find Curtis Reeves guilty of murder in the second degree with actual possession of a firearm. A firearm is legally defined as any weapon, including a starter gun, which is designed to or may readily be converted to expel a projectile by the action of an explosive. The frame or receiver of any such weapon, any firearm muffler or firearm silencer, any destructive device, or any machine gun. The term firearm does not include an antique firearm unless the antique firearm is used in the commission of a crime. To actually possess a firearm means that Curtis Reeves, A, carried a firearm on his person, or B, had a firearm within immediate physical reach with ready access with the intent to use the firearm during the commission of the crime. When there are lesser included crimes or attempts, in considering the evidence, you should consider the possibility that although the evidence may not convince you that the defendant committed the main crimes of which he is accused, there may be evidence that he committed other acts that would constitute a lesser included crime. Therefore, if you decide that the main accusation has not been proved beyond a reasonable doubt, you will next need to decide if the defendant is guilty of any lesser included crime. The lesser crime indicated in the definition of murder in the second degree is manslaughter. To prove the crime of manslaughter, the state must prove the following two elements beyond a reasonable doubt. One, Chad Oulson is dead. Pardon me? Yeah. And two, Curtis Reeves intentionally committed an act or acts that caused the death of Chad Oulson, or B, the death of Chad Oulson, that was A, B, the death of Chad Oulson was caused by the culpable negligence of Curtis Reeves. Every person has a duty to act reasonably toward others. If there is a violation of that duty without any conscious intention to harm, that violation is negligence. The defendant cannot be guilty of manslaughter by committing a merely negligent act, or if the killing was either justifiable or excusable homicide, as I have previously instructed you. In order to convict of manslaughter by act, it is not necessary for the state to prove that the defendant had an intent to cause death, only an intent to commit an act that was not merely negligent, justified, or excusable, and which caused death. I will now define culpable negligence for you. As I have said, every person has a duty to act reasonably toward others. If there is a violation of that duty without any conscious intention to harm, that violation is negligence. But culpable negligence is more than a failure to use ordinary care toward others. In order for negligence to be culpable, it must be gross and flagrant. Culpable negligence is a course of conduct showing reckless disregard of human life or of the safety of persons exposed to its dangerous effects, or such an entire want of care as to raise a presumption of a conscious indifference to consequences, or which shows wantonness or recklessness, or a grossly careless disregard for the safety and welfare of the public, or such an indifference to the rights of others as is equivalent to an intentional violation of such rights. The negligent act or omission must have been committed with an utter disregard for the safety of others. Culpable negligence is consciously doing an act or following a course of conduct that the defendant must have known or reasonably should have known was likely to cause death or great bodily injury. Aggravation of a felony by carrying a firearm. If you find that Curtis Reeves committed manslaughter, and you also find beyond a reasonable doubt that during the commission of the crime he personally carried, displayed, or used a firearm, you should find him guilty of manslaughter with a firearm. If you find Curtis Reeves committed manslaughter, but you are not convinced beyond a reasonable doubt that he personally carried, displayed, or used a firearm, then you should find him guilty only of manslaughter. Justifiable use of deadly force. An issue in this case is whether Curtis Reeves acted in self-defense. It is a defense to the crimes of second-degree murder and manslaughter if the death of Chad Oulson resulted from the justifiable use of deadly force. Deadly force means force likely to cause death or great bodily harm. The use of deadly force is justifiable if Curtis Reeves reasonably believed that the force was necessary to prevent imminent death or great bodily harm to himself while resisting an attempt to commit the felony offense of battery on a person 65 years of age or older upon him. And I'll now instruct you on the elements of battery on persons 65 years of age or older. The crime of battery on a person 65 years of age or older involves the following elements. 1, Chad Oulson actually and intentionally touched or struck Curtis Reeves against his will or intentionally caused bodily harm to Curtis Reeves. And 2, Curtis Reeves was at the time 65 years of age or older. It is not necessary to establish that Chad Oulson knew or had reason to know the age of Curtis Reeves. Unintentional touching or striking includes situations where Chad Oulson knows that a touch or strike is substantially certain to result from his act. A battery may be found as a result of the intentional touching or intentional striking of something other than the actual body of the person. However, the object that is touched or struck must have such an intimate connection with the person that it is to be regarded as a part or as an extension of the person. A person is justified in using deadly force if he reasonably believes that such force is necessary to prevent imminent death or great bodily harm to himself or another, or the imminent commission of an aggravated battery against himself or another. And I'll now instruct you of the elements of aggravated battery. The crime of aggravated battery involves the following elements. The first element is a definition of battery. 1, Chad Oulson actually and intentionally touched or struck Curtis Reeves against his will or intentionally caused bodily harm to Curtis Reeves. 2, Chad Oulson in committing the battery, A, intentionally or knowingly caused great bodily harm to Curtis Reeves or permanent disability to Curtis Reeves or permanent disfigurement to Curtis Reeves, or B, used a deadly weapon. A deadly weapon is any object that will likely cause death or great bodily harm if used or threatened to be used in the ordinary and usual manner contemplated by its design and construction. An object not designed to inflict bodily harm may nonetheless be a deadly weapon if it is used or threatened to be used in a manner likely to cause death or great bodily harm. Unintentional touching or striking includes situations where a defendant knows that a touch or strike is substantially certain to result from his or her act. A battery may be found as a result of the intentional touching or intentional striking of something other than the actual body of the person. However, the object that is touched or struck must have such an intimate connection with the person that it is to be regarded as a part or as an extension of the person. In deciding whether Curtis Reeves was justified in the use of deadly force, you must judge him by the circumstances by which he was surrounded at the time the force was used. The danger facing Curtis Reeves need not have been actual. However, to justify the use of deadly force, the appearance of danger must have been so real that a reasonably cautious and prudent person, under the same circumstances, would have believed that the danger could be avoided only through the use of that force. Based upon appearances, Curtis Reeves must have actually believed that the danger was real. If Curtis Reeves was not engaged in an unlawful activity and was attacked in any place where he had a right to be, he had no duty to retreat and had the right to stand his ground and meet force with force, including deadly force, if he reasonably believed that it was necessary to do so to prevent death or great bodily harm to himself or another, or to prevent the commission of a forcible felony. In considering the issue of self-defense, you may take into account the relative physical abilities and capacities of Curtis Reeves and Chad Oulson. If, in your consideration of the issue of self-defense, you have a reasonable doubt on the question of whether Curtis Reeves was justified in the use of deadly force, you shall find Curtis Reeves not guilty. However, if from the evidence you are convinced beyond a reasonable doubt that Curtis Reeves was not justified in the use of deadly force, you shall find him guilty if all the elements of the charge have been proved. Aggravated battery. To prove the crime of aggravated battery, the state must prove the following two elements beyond a reasonable doubt. The first element is a definition of battery. 1. Curtis Reeves actually and intentionally touched or struck Nicole Oulson against her will. 2. Curtis Reeves, in committing the battery, A, intentionally or knowingly caused great bodily harm to Nicole Oulson or permanent disability to Nicole Oulson or permanent disfigurement to Nicole Oulson, or B, used a deadly weapon. A deadly weapon is an object, any object that will likely cause death or great bodily harm if used or threatened to be used in the ordinary and usual manner contemplated by its design and construction. Great bodily harm means great as distinguished from slight, trivial, minor, or moderate harm, and as such does not include mere bruises. Possession of a firearm and discharge causing great bodily harm or death.